May I please, your lordship?
Yes.
The consent of the other side, I beg to mention item number 33 of today's list, your lordship. Lordship, in this matter, we are yet to file the affidavit in reply. We are seeking 2 weeks' time, lordship.
Okay. You are Ms. P. Pukon.
Yes, your lordship.
Ms. P. Pukon, Learned Counsel appealing for the petitioner has submitted that the petitioners would pay for some accommodation to file the affidavit in reply to the affidavit in opposition filed by the respondents. Full stop. List this matter again after how much time?
After 19th, your lordship.
We'll give you 3 weeks time.
Fix a date, Lordship.
Huh?
Fix a date. So there is
Fixing a date is not very
a
conducive.
interim order of fighting
There's an interim order, lordship. A date may be fixed, your lordship.
against us, my lord.
List the matter after 10 days, allowing the list the matter, allowing 10 days time, to the petitioner to file the affidavit in reply. List this matter again on 21st of November 2025 for further consideration.
Lordship, there is also an interim.
The interim order passed earlier will continue till then.
Observed, your lordship.
Yes.
Lordship, with the consent of other side, I beg to mention item number 11.
11.
Yes,
Lordship, I'm petitioner, Lordship. Can the matter be fixed on 6th, Lordship? Because 6th of
December.
That
Thursday.
next Thursday.
13.
13 years.
What is the urgency?
Urgency is there. Our retail outlet is closed since 2-3 years.
Uh-huh.
Our retail outlet, no, BPCL is closed at 2 years. It is terminate matter, Lordship.
Okay. An adjournment slip had been circulated on behalf of the respondents, praying for taking up the matter, or for praying for not taking up the matter today. Full stop. The consent of the counsel for the petitioner had been obtained, and on a joint request, let this matter be listed again on, you said 13th. 13th of November 2025 in view of the urgency expressed.
Right, Lordship.
Hmm.
Lordship, I beg to mention item 18. I'm paying adjournment for a week, madam. Item 18.
What cause do we write?
My lord,
What cause?
my lord,
Some reason.
reason, my lord, I have not find out the file. Misplaced something.
Mr. M.R. Khandakar, Learned Counsel, appealing for the petitioner, has submitted that he would require some accommodation today. Full stop. The prayer is not objected to by, yes. Who's appealing for? No,
Comment.
not objected to by the Learned Counsel, appealing for the respondents. List this matter after a week on a date to be fixed by the registry on his prayer. I'm late.
Lordship, the consent of others, I beg to mention item number 19 of the daily list.
9.
19. 1.
19. Yes.
Seeking for an adjournment, lordship.
Are the pleadings complete here?
Lordship, we are yet to file the affidavit of opposition.
Opposition. Learned Counsel, appealing for the respondents, submit that some accommodation may be granted to allow them to file the affidavit in opposition. Stop. The matter is of the year 2023. List this matter again after 4 weeks, allowing the respondents to file their affidavit in opposition in the meantime. Stop. Yes.
Okay.
Yeah, period, Lordship. Lordship, I have to mention for listing of a lead petition, Lordship. It was listed on the last
Listing.
listing.
There is a senior bench. Why to this bench?
This is a regular bench, Lordship.
Huh?
This is a regular bench, I think, Lordship. That bench will sit if time permits, Lordship.
Today.
Yes.
What is the urgency today?
Urgency, Lordship, the petitioner is a police station, Lordship.
Mm.
There was a hearing, Lordship, on 4th of 11, November, Lordship.
Mm.
Issue involved regarding the caste certificate, Lordship.
Castle.
Caste certificate.
Is it Sylvan's 4 or 5 months?
This is five.
বাইদেউ এইটো senior bench mention কৰিব লাগিব senior bench it has to be mentioned before the other bench.
It's in the DB one, Lord.
Huh?
Just as the order is in DB one. If time permits. Let's take it. Five.
Five.
That's five. The issue involving the regarding custody. Custody.
Just wait,
That's
let us finish the other part, let me think.
Right.
Whether there is,
Yes.
Direct master phone to help. Huh? No. If he agrees with this, huh? The college teacher of the bench taking. Well, could you look some bench con hoodie? Kindly give her the number
Lord.
so that we can trace out whether it is bench 3 or bench 4.
Lord.
Yes,
May I please, I'd like to mention item number 23.
23,
No, 14 Miller, sorry.
14.
One.
Yes,
This is a matter pertaining to settlement, Miller. Settlement BOD already over Miller.
so
And matter is in fact
you are appearing for the
a respondent.
respondent, the petitioner has to say so.
Miller earlier twice listed.
Let the matter reach, we shall see if none appears, we'll do what it is. Yes,
This is my lord, with the consent of the other side, I'd like to mention item number 17 of the daily list, my lord.
17,
My lord, conducting counsel, Mr. B. Gogoi is out of station, my lord.
yes.
The matter may be taken up any other day, my lord. 17, 17.
You inform the
Other
other
side,
side.
my-
It has been submitted that the conducting counsel, Mr. B. Gogoi, that additional advocate general is out of station. And therefore an accommodation may be made today. Also accordingly list the matter, when do you want? After a week, on a date to be fixed by the registry.
Bless me.
Make please, Lord.
Yes,
Lord, item number 3, Lord.
3.
I am for the petitioner. It has become infructuous.
Mr. R. Dubey, Learned Counsel appearing for the petitioner has submitted that this writ petition has become infructuous and would not require further adjudication. Full stop. Accordingly, this writ petition is closed as infructuous.
Now for the response.
Record is in file. Yes,
I'd like to mention item number 12, Lordship.
12.
Yes, Lordship.
Yes.
We need some more time to file affidavit in opposition, Lordship.
You are for the
Respondent number 2, Lord.
respondent number 2. The council appearing for the respondent number 2 has made a prayer to be accommodated so that they may file an affidavit in opposition to the writ petition. Full stop. Prayer not opposed by the council for the petitioner is granted. List the matter after 3 weeks, allowing the petitioner to file, respondents to file their affidavit in opposition.
May I please, Lord?
Mm.
Lordship, back to mention item number 23, Lordship. Lordship, here the petitioner has engaged different counsel, Lordship. We has given our NOC. Lordship, our names from the cause list may be strike out.
Let the matter reach. Perhaps
Well,
the
I'm
new
for the-
councils will come on record. With
I'm the
have your
new
names.
counsel,
Okay.
madam. I'm the new counsel.
Let the matter reach.
Okay, Lordship. Please.
May I please, your lord?
Uh-huh.
Lordship, I beg to mention item 13, your lordship.
13.
Yes, sir. Yesterday we have given the adjournment.
Thirteen
council
number,
out.
all of our নিকলে জানো adjournment slip লিখে।
1 3.
হ্যাঁ? যে a adjournment slip has been circulated by the you are for the petitioner for the petitions which is not objected to by the council for the respondents. So accordingly list the matter after
3 weeks, your lord.
3 weeks on a date to be fixed by the registry.
Interim order, there is interim.
Interim order passed earlier shall continue. Yes.
Apply.
My lord, so item number 15 and 16,
15 and 16.
conducting counsel is also out of station. Kindly adjourn the matter after a week.
Who is out of station?
Yes, Lord.
It is submitted on behalf of the petitioners that the conducting counsel for the petitioner is not available in station today. And accordingly, some accommodation may be granted. So, place this matter after 2 weeks, on a date to be fixed by the registry.
After 1 week, my lord.
Huh?
After 1 week.
After a week, 2 weeks, maybe. Both the matters, 15, 16.
Oblige.
Yeah.
May I please, my lord?
Yes.
I'm sorry, my lord, in this case, I have failed to take the steps on respondent number 6, 7, and 8, my lord. One the time may be guaranteed, my lord, I will take the steps.
What is the subject matter?
My lord, in this case, my lord, the land, the petitioner is holding a land which was earlier a annual land, annual patta land,
Hmm.
but that was converted into the government land, man.
Hmm.
All the representation and all, everything was
And
submitted, but,
you have an interim order in your favor.
yeah.
Is there an interim order in your favor? From 17,
No,
this matter
no.
is pending.
No, my lord, what happened? No, there is no interim order, my lord. This petitioner, my lord, expired, my lord. So thereafter substitution was filed, but out of the 5 legal heirs, my lord, 2 has filed the application. So other 3 has made as a respondent, my lord. So they were implemented only on 17/9/2025, my lord. The notice was issued, my lord. 17/9.
Mr. R.S. Mishra, counsel appearing for the petitioner has submitted that by oversight, the steps required to be taken by order dated 17/9/2025 were not taken, and therefore he prays that he may be allowed another opportunity to take the required steps. Full stop. Allowing his prayer, the petitioner is allowed to take steps for service of notice upon the respondent number 6, 7, and 8 by speed post, as well as through usual process within a week from today. List the matter after 4 weeks.
Obliged.
Yes.
Obliged.
कौन कुमार है?
You can kindly see the last order
Yes.
that has been passed by this court, man. 30/10, man. Last order that has been passed by this.
Mm.
court. I think 13/10, a very detailed order has been passed. 13/10 was the, 18/10 was the order. A detailed order was passed on 18/10. Everything is here, my lord. What is the
Yes, have you filed
submission?
the response to the additional affidavit?
Lordship, yes, Lordship, we have communicated to the department also
Ah.
regarding this matter. We have also been assured that we'll be receiving the records also, because Lordship had asked for the records as to why there is an inconsistency.
Huh.
Those records I have been assured that we will be receiving by tomorrow. And secondly, Lordship, this matter has been taken care of by Mr. B. Gogoi, who, as your Lordship also has been informed in the morning, is out of station.
No, give us a convenient date for him. Then on 30/10 he was not here. Today
No,
he
no,
is not here.
Lordship. That is why I apologize, Lordship. Any day
Ah.
next week, Lordship. We will be ready
After
with
the-
the records and everything.
My your lordship has, what I'll respectfully submit, my lord. Mr. Gogoi is not there. I can't
Ah.
say much of it. But your lordship is in session, hardly matter. So let it be for further hearing whenever your. After 2 weeks, my lord, further
By
hearing.
when will you have the records?
Records I'm assured that we'll be receiving by tomorrow.
But let them take 2 weeks, my lord. There is no problem. my
And
lord.
what about that additional affidavit which was not
See,
responded to?
Receiving the communication as well as the records for this, as to why there is an inconsistency between the letter which
The
was.
next day again you will say we'll have to bring it on affidavit.
Lordship.
List this, heard Mr. Dida Standard Senior Advocate appearing for the petitioner, assisted by Mr.
Yes.
Stop. This court had sought for certain instructions by the order dated 13/10/2025, and on the last date of listing, an adjournment was sought for on the ground of the absence of Mr. B. Gogoi Learned Advocate General, as he was engaged in some other matter. Full stop. Today, this court has been informed that although the instructions would be don't write the word although. Today, this court has been informed that the instructions would be received by tomorrow. And the department would also be in a position to respond to the queries made. Full stop. The matter relates to the year 2021 and has been pending for payment of for adjudication on the payment of the bills raised by the petitioner. Full stop. The matter was also heard extensively on the earlier occasion. List this matter in the first week of December 2025 for further hearing, on which day the respondent shall ensure that the instructions as required are available, comma, it is made clear that even in the absence of instructions on the next day, the matter will be taken up for disposal.
Briefly of this.
Yeah, please, your
Yes.
lordship. Lordship, this the land acquisition matter, your lordship. Lordship, we have forwarded a proposal to the finance department in the month of September, but finance department has returned our proposal stating that you take the view from the judicial department. Till the September 2025, the file is in the judicial department, your lordship. They have not given their view, so we could not forward it again to the finance department, your lordship. This is the current position, your lordship.
No, that was the position in 22922025.
Yes, your same
Month has
position,
gone.
lordship. Because judicial has not released the file, your lordship.
The land has been acquired.
Yes, your acquired, your lordship.
The land has been acquired, then why, after the acquisition, what is the delay?
Lordship, to release the amount, we have to take approval from the finance department. The finance department said that we have to take first. we have to
When
take-
some land is acquired, the land is acquired and then a valuation is done.
Yes, yes, that all is done. your
Valuation is,
lordship, by the
everything is
deputy
done. Now the
commissioner.
finance department is asking for opinion of the judicial
Judicial
department on already acquired piece of land.
Yes, your
Is the
lordship.
finance department a party here?
Yes, yes.
lordship.
Who appears for the finance department? Finance department or scroll to the auction? Scroll to the after some time. We take this after some time.
Well, in this case, in terms of the last order, the petitioner was to submit certain documents after due attestation by revenue official. She could not collect the revenue attestation of signatures from there. Therefore, I need some further time.
Otherwise, everything is completed, but because that document, some misunderstanding in name, and some document has to be countersigned by the revenue
Officials.
officers.
She couldn't get the signatures of the revenue official attestation by the revenue officials done.
The prayer is for what?
Prayer is for family pension. That's
no.
freedom fighters family pension.
Freedom Fighters Pension. It is sanctioned, my lord, only to correct some name and to signature in some document by the revenue officer. For that purpose only.
There's an instruction, which they place, that she has to sign certain papers, for example, bank account, identification marks, etc., which has to be, attested by the revenue official, That revenue, attestation could not be done, so far, This is some further time.
On a joint prayer made by Mr. M. Dr. Leonard Council appearing for the petitioner. No, on a prayer made by the Leonard Council for the petitioner, Mr. M. Dr. comma, which is not objected to by the Mr. K. K. Parashar Leonard CGC appearing for the respondents, comma, list this matter again after
2 weeks time, Lordship.
2 weeks on a date to be fixed by the registry. Full stop. The court has been informed that certain formalities remain to be completed in the matter, and therefore the time has been sought for.
I am for only 1 and 2. Others are there.
R.K. Talukdar on behalf of Honorable Sultan. After 2 weeks. Yes, sir.
Lord, short point involved is whether, my lord, a board of directors can be constituted in violation of the mandate of section 9, 35 and 43 of the Cooperative Societies Act. Now, what had happened, my lord, this particular cooperative society AGM was held on, if your lordship would kindly come to page number 63. I'm referring to the resolution of the board of directors. I'm sorry, Miller. Page number 43. Resolution number 3.
Yes.
The house forms the full-fledged board of directors of Khair Media Samvai Committee as follows. Now kindly say there are 11 directors, Miller.
Hmm.
These are all directors.
Hmm.
The house resolves to send this proposal to Assistant Registrar of Cooperative Societies for approval.
Yes.
If your lordship should kindly come onto the next page on top,
Approved.
there's the approval.
Huh.
Now, my lord, what I would like to contend is that this could not have been done because this is against the mandate of the Act and the bylaw. If your lordship should kindly take the Act for a moment, Cooperative Societies Act. Lord will kindly come to section 9.
Bylaws.
I think it is on page 15 if you are
Yes.
holding the same book.
Yes, yes.
Section 9.
Hmm.
A cooperative society shall frame their own bylaws and affairs of the cooperative society shall be managed in accordance with the terms, conditions and procedures specified in bylaw.
Hmm.
2. Subject to the provisions of this act, the functioning of every cooperative society shall be regulated by its bylaw.
Hmm.
3. The bylaws may contain such matters as decided by the General Assembly and shall be specific and confined only to matters provided in Schedule B. However, the bylaws of the society shall in no case supersede the provisions of the Act. Therefore, Schedule B would indicate what all are the activities. Then before that, if your lordship would kindly come to section 35 at page 33.
Board.
There shall be a board for management of every cooperative society registered under this Act. The directors shall be elected in accordance with the provisions of the bylaw. So when it comes to election of board of directors, it will be elected in accordance with the provisions of bylaw. Then my lord will kindly come to section 42, subsection 3 at page 39. Any casual vacancy in the office of the director shall be filled in accordance with the provisions of the bylaws, and directors so elected shall hold office for the unexpired term of his predecessor. Subsection 3 of 42. Yes. Now, my lord will kindly come to the schedule.
$100.
Yes, my lord. Schedule B. Please come to me, lord, section page 101.
Yes.
Now, what all are the matters which will be determined by the bylaw? It is indicated. 6. Size and composition of board of directors. Now, my lord will kindly come to the page number where I have quoted the bylaw, my lord.
Page number?
Paragraph, 1 second, my lord. Page number 16.
So I mean constitutional board of directors.
Yes.
Yes.
To manage the affairs of the society, 15 members board of directors, including president and vice president, shall be constituted. Well, this is an English translation. I am holding the Assamese copy also. I'll hand over, my lord. So this is to the best of our, in fact, it reads as 21. Yes. সমিতিখন পৰিচালনা কৰিবৰ বাবে সভাপতি আৰু উপ-সভাপতিক লৈ 15 জন সভ্যৰে কাৰ্যকাৰী কমিটি গঠন হ'ব. So 15 is the mandate. Now, what had happened, my lord? Apparently, against 3 directors who were elected, there were some allegations that they could be defaulted. Therefore, the ARCS, Asian Register of Cooperative Societies, my lord, he approved in case of 11.
Yes.
Then a demand was made that until that issue is resolved, the president and chairman and vice chairman should not be elected,
Elected.
which was rejected. I am before your lordship because of that. Now the question is, if there are less than 15 members, whether it will validly constitute a board of directors, when the language of the statute is so unequivocally clear, Mila. Now what had happened, the present petitioner and two other, they filed a representation saying that you don't go ahead with the election. If your lordship would kindly come to page 52. This was the representation which was filed, Miller, on 28/9/22. I'm reading the first subpara, that as per the bylaw, there should be 15 members in executive committee and chairman and vice chairman should be elected from amongst 15 members. But only 14 members in total were elected, unopposed in the election. Furthermore, the approval of 11 members excluding 3 on the basis of objection has also been violated in rules and the act. That on the basis of the approval dated 29/22, the secretary of the Samvai Committee has issued a letter to 11 inviting them to the meeting stating that chairman and vice chairman would be elected on 22/9 in the office of the Samvai Committee. That we, the undersigned 3 members, raised a protest on 22/9/22 with a demand to postpone the meeting as it was illegal and invalid. 3 members out of 14 elected members have been excluded and therefore entire election should be cancelled. The election of chairman and vice chairman with the approval of 11 is not valid and legal. On 22/9/22, we, the 3 members, raised a protest for about an hour with demand of postponing the meeting, but the president of the meeting was unwilling to postpone the meeting and chairman and vice chairman were elected from amongst 8 members and the list of illegal 8-member committee was submitted to the president of the meeting. So, this is our grievance.
So there were 11 members who were approved. Are you amongst them? No.
Yes, I am one of them, my lord, who was approved. But I say, me and
You
two
are three petitioners here.
3, yes, out of the
3, 1 is an approved member and 2 are
in the petitioner number 1, yes.
2 are unapproved.
Yes.
Now your case is that since there are only 11 approved members, the chairman and the vice chairman could not have been elected amongst those 11.
Yes.
Unless the 15 is fulfilled, the election of
To
the
defer it. To defer it. So this is my case.
But this representation,
Yes,
we see at the end at page 53,
yes, my lord.
it was only with a prayer for supply of the resolutions.
Not true, my lord.
There was no other prayer.
No,
There was no other
true.
request.
But my lord, at the same time, the other perspective was also made, my lord.
Mm.
That is why we are before your lordships. I'm one of the elected. All that I said is postpone it. Let the issue of this 3 be decided. Then you take a call. Now, therefore, now, holistically speaking, my lord, now on the teeth of section 9, 35 and 42, read with bylaw 21, whether in the absence of 15, the chairman and vice chairman could have been elected. Whether the ARCS was justified in giving approval to the resolution of 22/9/22.
So now we have to decide whether only 11 members, if approved, can the
Then
could
can
the
they elect-
election of the chairman and the vice chairman go ahead?
Yes.
Or otherwise, if we say if the quorum is not met of 15 members, then still the proceedings be held be valid.
Yes. That is my case.
Yes, yes.
My lord, basically, the issue boils down to this point that whether the constitution of a board short of 15 members is valid or invalid. Otherwise, your lordship will see here 11 member is not the, my lord, determining factor. Because otherwise also the election of 14 members was approved. 14 members,
Not 50.
not 15.
Hmm.
Because total 14 candidates tendered their nomination.
Hmm. 14 candidates were there.
Yes. Now, in terms of the election rules, if, my lord, the nomination is equal or less than, my lord, the total seats, my lord,
Seats,
yes, then they are uncontested. Election will be held if even one nomination exceeds, my
Is
lord, the
more.
total.
Yes.
So therefore, here was a case that they were elected uncontested.
Hmm.
Now, the question would be whether even then, when it did not fulfill 15 members, even then, whether the board would be invalid.
Hmm.
The requirement under the bylaw 15 has to be read with the scheme of the act. Because your lordship is aware that the bylaw is always supplementing the scheme. madam.
That is what the
Yes.
provision also says.
Yes,
Section 9(3).
it says.
Provision
madam.
says so.
So therefore, the interpretation has to be such
Hmm.
that it is inconsistent with the scheme of the act. If the scheme of the act permits the constitution of the board short of 15 members,
Hmm.
then your lordship will not interfere.
Show us that it.
Yes, I'm coming to that, my lord. Firstly, if your lordship comes to 31, section 31.
Hmm. 31 we have.
Sorry, my lord, it would be 35. I would be also be reading what my learned senior, my lord, has referred to.
Oh.
Section 35, my learned senior has referred to 1.
Hmm.
I'll come to 2. 2 says, my lord, that the board shall consist of maximum 21 number of directors.
Hmm.
Now, lordship will see the upper limit is prescribed. It does not contemplate what will be the, my lord, minimum number of members.
That is when we fall back on the bylaws.
Yes. Now, your lordship will also come to bylaw. What does the bylaw say?
Where is the bylaw? Is it before us? Anywhere.
My lord, I am having the vernacular one. Yes,
One
yes,
copy would be
yes, yes. Wonderful.
helpful.
Right, okay. Page 22, Miller. Hey, extra.
Bylaw এখনে আছে।
22 অসমীয়াত আছে। পাইছে।
Yes.
Yes. Now, my lord, 21(1) says, কমিটিখন পৰিচালনা কৰিবৰ বাবে
Hmm.
সভাপতি আৰু উপসভাপতিক লৈ 15 জন সভ্যৰে কাৰ্যকৰী কমিটি গঠন হ'ব।
Hmm.
15 members. Now, if 21 is read, my lord, with 26, কাৰ্যকৰী কমিটিৰ সভা পৰিচালক কমিটিৰ সভা মাহেকত 25, my lord, sorry, 25. কাৰ্যকৰী কমিটিৰ সভা, page 28. পৰিচালক কমিটিৰ সভা মাহেকত এবাৰ বা প্ৰয়োজন অনুসৰি বেছিকৈ হ'ব পাৰে। উপস্থিত থাকিলে সভাপতিয়ে সভাপতিত্ব কৰিব। তেখেতৰ অনুপস্থিতিত উপসভাপতিয়ে সভাপতিত্ব কৰিব। 9 জন সভ্যৰে সমিতিৰ ঠুল হ'ব। The requirement of quorum is 9. Now, if the board is constituted or if the members present are 9, my lord, then the quorum is achieved, my lord.
Karyakari committee is the executive.
Yes, board of directors meeting, Karyakari committee. my lord, 20, the provision of my lord, constitution of the board cannot be read independent of 26, 25. The moment, my lord, my respectful submission is the quorum is achieved, there is a valid board. Now, I'll come to other provisions of the statute also, ma'am.
So if 9 directors assemble, the quorum is complete
Complete.
and the proceedings can be.
Yes, proceedings can be held. Those proceedings are valid in the eye of law.
Because they have to elect someone from within themselves.
Yes. Now,
Okay.
your lordship will kindly come to section 41(2). My lord, this is more important in view of the consequence which my lord 41(2) entails. With regard to election, my lord, 41(1) is with regard to holding of the election, where the registrar would be the supervising authority. Now, 2 is important. Your lordship has got it, my lord. The election of directors to a board shall be conducted before the expiry of the term of the board, so as to ensure that the newly elected members of the board assume office immediately on the expiry of the office of the members of the outgoing board. So, how it is related, my lord, to the constitution of the board, or to, my lord, the bylaws, more particularly 21 and 25. Now, the requirement of 41(2) is to hold the election before expiry. Now, non-holding, my lord, it entails a consequence. Now, your lordship will come to 41(4).
See, and if it does not happen, the board will dissolve
Board will dissolve,
on the expiry.
and my lord, the board members, they would incur disqualification. They cannot participate in the election. Next, which is going to be held. They cannot tender the nomination. So essentially, my lord, it begs the question whether the board will wait for tendering of 15 numbers of nomination until the 15 numbers, my lord, candidates tender the nomination, whether the board will wait to hold the election.
Elections were held.
Election, my lord, if the interpretation.
Board of director election was held. Now,
No,
who
what I'm
would
trying to
sit as
say,
chairman and-
what I'm trying to say, if the interpretation, my lord, of the petitioner is accepted, that unless there are 15 numbers, which, my lord, gives rise to a valid
Okay.
board. So therefore, there has to be 15, my lord, nomination papers. Unless there are 15 nomination papers, there cannot be a valid board if the interpretation of the petitioner is accepted, my lord.
In
But
the
it-
absence of a valid board, the other directors term will expire automatically
Automatically
and
expire.
they will also
Also
incur
incur disqualification. So therefore, my lord, my humble submission is 41(2) and 41(4). My lord, is an overriding, my lord, provision which mandates that the board has to hold the election before expiry of their term. They cannot wait that there are no 15, my lord, nomination papers, so we are not going to hold the election. If, my lord, there are 9 nomination papers, even then, my lord, constituting the quorum.
there is a flaw. There is a flaw. We'll just interact in between, although I'll be stopping you. 4 says when the board fails to arrange for holding of the election,
Yes.
not that the election requires to be held. If the situation that you had said, if there are lesser number of nomination papers and the election fails for that, the board is not responsible, the earlier board, because the board arranged for the election. The election process failed. Then the board cannot be held responsible.
No, my lord, I'll come to that.
So even if there are 14 members, the new board would be there.
Yes. If this
with even 14 members.
If
Why?
my-
Because the earlier and now it will not be a situation under 4.
Yes.
Even if you go by Mr. Chaudhary's argument, because only when the board fails to arrange for the election, that it incurs in disqualification and it expires on the term. If it arranged for the election, whatever reasons the election did not take place, It made the arrangement.
Yes.
Arrangement failed.
My
How can the board of directors be responsible?
No, there is another provision.
That will be-
Section 40 is there. I'll come to that.
Ah.
But even then, if your lordship goes by 41-2,
Hmm.
41-2 makes it very clear
Hmm.
that before expiry of the board, election has to be held.
Hmm.
Now, if the argument of the petitioner is to be accepted, that short of 15 members, the board is not valid.
Hmm.
Essentially, the argument is, if I have rightly understood or not mistaken,
Hmm.
that in terms of the bylaw,
Hmm.
the board has to be invariably constituted by 15 members. Short of 15 members, the board is invalid.
Hmm.
Now, my humble submission is the present board, which is running the show, has to hold the election in terms of 41-2. Irrespective of the nomination papers, whether it is 15 or less. If it is less than 15, then also, my lord, the board will come into play. In that context, my lord, can we say that the board is invalid? There is a mandate of law, my lord.
Okay.
My lord, perhaps I'm not able to put across my point.
No, I've understood you. What you are trying to say is, if less than 15 members is an invalid board, then the very board, then the directors who could not arrange for 15 directors, the earlier board who could not arrange for 15 people to participate in that, to contest an election, contested or uncontested, to participate in that process.
Right.
On their failure, the entire board has to be, the earlier board has to take the burden of
Consequence.
not being able to
Yes.
have the requisite number of directors on the next board.
Yes.
And therefore, they would be incurring the disqualification.
Correct.
That cannot be the intent of the law.
Absolutely correct. And
And
whether,
therefore, even with less than 15 members, if there is a board of directors and the quorum under 9 is met, the board remains a valid.
Valid.
So anything beyond 9 is a valid.
valid board.
Anything below 9 may not be a valid,
Valid
board
board.
because it does not have the quorum.
Yep.
And then perhaps the disqualification and everything also fits in.
Correct.
That is what your argument.
Absolutely correct.
You have understood. it.
Absolutely correct. I'm obliged. And the, my lord, conversely,
Hmm.
whether the board, my lord, will wait, my lord, for indefinite time, that 15 members will come
Hmm.
forward and tender the nomination.
Hmm.
So my humble submission, my lord, the argument, my lord, may not be, my lord, inconsistent with the scheme of the act.
Hmm.
And more particularly, this is reinforced by 41-9. If your lordship comes to 41-9, section 41-9. What does 41-9 say, man? This makes, my lord, the position very clear. May I read it, my lord? Where there are vacancies in the office of the director. So vacancy is already contemplated by the statute, my lord. And where there are no sufficient number of directors to constitute a quorum. Now, if your lordship reads, my lord,
Even if there are
41-9.
lesser numbers, you can co-opt members
Absolutely
to complete
correct.
the quorum so that the functioning of the society does not stop.
Absolutely correct.
Hmm.
If there is no quorum, then there is a provision for co-opting the members. Well, in the present case, there is a quorum. So whether the board will co-opt or not, it's up to the board. But the moment, my lord, the quorum is secured or achieved, and board is constituted by at least 9 number of directors, my humble submission, my lord, it's a valid board. Because it can take decisions validly. It is authorized by the bylaw under section 9. So under such circumstances, my lord, reading the bylaw with 41-9 makes the position clear that short of 15 members would not render the board invalid. This is permissible under the scheme, my lord. And the argument, my lord, of the petitioner is accepted, my lord. That would be amounting to, my lord, give, my lord, the bylaws, my lord, upper hand. Otherwise, the bylaw is always subservient to the scheme, my lord. It is supplementing the scheme. And going through, my lord, the scheme of the act as well as the bylaw, if I'm not mistaken, my lord, nowhere it is, my lord, contemplated that below such and such number, my lord, the board will be invalid.
Where
On the
was
lower
it?
side, there is no prescription, my lord. On the upper side, my lord, the prescription is under section 35(2), that maximum 21 numbers.
So, by law, 21 says 15 members. By law, 25 says 9 will form the quorum.
Yes.
Petitioner's argument that 15 members, unless there are 15 members, more so when 3 have been disqualified, 3 have not been approved despite coming in uncontested for whatever reasons. Because there were less than 15 members, the chairman and vice chairman should not have been allowed to be processed. And your argument is that since 9 forms a quorum for the bylaw itself, 15 may be the maximum number of directors. Act allows lesser than the numbers given in the bylaw to go ahead with the functioning of the cooperative of the society, if required, even by taking on co-opted members, but the functioning has to go on, and therefore there is nothing wrong in 11 of them participating to elect a vice chairman and a chair.
Yes. And more so, Malus, the petitioner has participated in the meeting. He was a part of the meeting.
That is what
Yes.
that is
Now,
what the
whether he can
representation
now
says.
come and say, my lord, that it was a
That part, once
No,
you are
just
once
I'm-
once you are
on
once you are
facts,
not heard, once you are not heard in a particular forum,
Well,
you can always come to another forum and say that I was not heard.
yes. Yeah.
Is it not? That is what his representation says. I was not heard, sir.
Correct.
That part we will not.
Yes. Sir.
We will not even like to take into.
And 43(5) is also relevant with regard to the quorum, my lord. Under the Act, 43(5) says, the quorum for a meeting of the board shall be such as may be specified in the bylaws, but shall not be less than 50% of the total number of directors of the board. Even
And
if
this-
the total number of directors is considered to be 15, then 7.5. Rounding off, next integer 8. In the present case,
43(5).
43(5). So in the present case, my lord, 11. There are 11.
And what happens when there is a vacancy to the post of chairman and vice chairman of the board? In case of vacancies, what happens? Suppose some vacancy arises, then what happens? Can we have something?
I think 42(3).
42(3).
That is, my lord, in respect of a director. But
Because the chairman or the vice chairman has the last vote if there is an equal voting. So
after the election, my lord, the first meeting is held from amongst, my lord, the directors who are elected. And they elect from amongst themselves the president or vice president in the first meeting, which was done in the present case.
even in their absence. What else? Yes, sir. Anything more?
Yes. My lord, in fact, I have stated in my affidavit, that is page 61, I have stated the doctrine of necessity. Even if, my lord, it is assumed to be irregularity, but the doctrine of necessity will override, my lord, the doctrine of bias. If your lordship comes to page 61 of my counter affidavit, 5D.
Since you did not have the members, you had no option but to go ahead.
Yes.
Okay.
And my lord, I'm not reading it out, I'm just pointing out to your lordships. And my entire submissions, my lord, your lordship will find from para 9 onwards. I have quoted all the relevant provisions of the statute. And basically what I have already submitted, your lordship will find from para 9, 10, 11, 12, 13, 12 and 13. From 9 to 13, my lord. My stand is,
You also take a stand that remedy lies under section 111 before the respondent number 2.
Maximum যে আছে
Okay.
15টাই তো কোট আছিলে
হয়তো বাইলতে আছে স্যার।
বাইল।
তাতে আছে ম্যাক্সিমাম তো আছে statute আছে 35 to
35 ডিগ্রি কি কথা কইলাম আমি
Notes বলে কেন আমি খালি 6 to 13 টা কই দিম 6 to 13 আমি কই দিম
হবো
The
Yes.
specifically para 13, my lord, I have stated.
13.
13, 1, 3.
Okay.
The,
I am appearing for and on behalf of the board of directors 6 to 13
Hmm.
supporting the stand of my learned friend 49 41 9 minutes.
If you say learned friend, we do not know which of them is your.
I'm learned.
Yes. Huh?
It says the event there
From
is
6 to 13.
6 to 13.
Okay. You are referring for 6 to 13 and you're supporting the
My
respondents.
Yeah. The 41 9 says the event there is no quorum, there is a provision of co-opting member.
Huh?
Even there is no quorum, the board is not invalid.
Because they
there
can
is
go
a
for a cooperative
provision of-
member. That is what he has argued. Yes.
That is
Milord, my perspective is simple, Milord. I was only testing the argument, Milord. Even I was not very convinced when these people came. But I'll just make one small submission, Milord. What my learned friend has submitted is something which is plausible.
Hmm.
I'm not saying that what he said is wrong or something. It's plausible. I was only wondering one thing, Milord, just placing this for your lordship's kind consideration. Will your lordship not make a distinction between constitution of board of directors and actions taken subsequent to the constitution? So we are at the threshold. We are at the stage of constitution.
Hmm.
Now, is it not a case, Milord, where the language of the statute read with the bylaw,
Hmm.
I mean, is really very strict, Milord? And more so section 35(2), when it comes to the maximum number, it says, but when it comes to minimum, it has not specified anything. But going by the literal interpretation of section 9, 35(1), 43, 42(3),
Hmm.
read with bylaw number 21, there is no escape from the conclusion that 15 member alone can constitute a board of director of this particular, I mean, cooperative society.
If we go by.
And look, when it comes to, look, what is a quorum?
Quorum?
Quorum is a concept which is normally associated with holding of a meeting. How many members would constitute the quorum? That is for, my lord, we are at the threshold. We are at the stage of constitution of a committee. Now, once committee is constituted,
Then
there may not be, there may not, 15 members need not be present.
So,
I was only trying to insist upon that point. my lord.
if his argument is taken.
Yes.
And suppose there are only out of the 15, only 2 persons contest the election.
Then
13 don't contest
Ah.
for whatever reason.
Ah.
2 persons contest and 2 persons they are elected uncontested. So now the board would consist of 2 directors.
2 direct.
Can it be called a board? If
Can
you
board.
take his argument in totality.
Yes.
And if
So
we take
therefore-
your argument in totality,
Yes.
anything below 15 is gone. So even if there are 14.
I'm on
it has to-
constitution. I'm not,
has to go.
my lord, managing the affairs of the quorum is a concept which is also synonymous with, my lord, functioning of the cooperative. There are 15 elected members. They need not be present. 9 is good enough.
In some cases, 6 plus 3 co-opted will do.
Going by the spirit of the statute where it says the bylaw cannot override the act, even 8 would constitute. Because 15 being the outer limit,
Yeah.
7.5 is 8. So we are not concerned with quorum of a meeting. We are concerned with constitution of a society.
Board.
Whether in that scenario, I mean, what would be the, yardstick? That's the point, my lord. My lord, when these people came to me, I was myself not convinced. Then when I examined the matter from this perspective, I thought, let us know why not test our argument.
Otherwise, allowing a cooperative society to function
Yeah.
with whatever number of directors to their convenience, if it is not illegal, there is a tendency to
harsh.
let it.
It'll be too harsh. And secondly, Lordship has pointed out a very pertinent thing. When will they incur the disqualification?
It's only when they fail to arrange for it, not when they fail to get it done.
Yes.
They need to make the arrangements. Someone does not participate, people do not vote, they cannot force people to come.
My lord, in a statute, it has to take care of so many things. Initial constitution, then how a cooperative society will function, how a director would be, as chairman would be selected, how a vice chairman would be selected. There are different aspects.
This is the question now which has held us up, otherwise we were making up our minds slowly. Yes,
So,
but
like-
you say the board would not be constituted unless there are 15 members. Your bylaw says it has to be 15 members. Unless there are 15 directors, there is no board. Whether
Sorry, Mr. I'll give one more example.
Ah.
Lok Sabha would constitute, say, 500 MPs. But necessarily there is nowhere written that 500 has to be there to constitute Lok Sabha. It consists of 500
Sabha will
members.
have 500 MPs.
Yes.
It does not say that 500 MPs will make the Lok Sabha.
Yes.
That is the difference.
That is the
the senior council is trying to draw.
Yes.
Unless you have 15 directors, there is no board.
No
Because of
valid
the
board.
bylaw. So you need to go for a fresh election, fresh
Exactly.
arrangement, whatever you want to do, but you must have 15 people on board for the board of directors of the society to exist.
Yes.
Now, after the 15 people come together, 9 of them, and in some cases where you are talking of co-opted members, 6 of them plus 3 co-opted, you can carry on the functioning.
These are situations
But to
subsequent.
bring it into existence, first thing you require is 15 directors. Unless the 15 directors are there, there is no board. If there is no board, quorum, numbers, nothing will come. That is his argument.
That is my.
Perhaps I have an answer to that.
Yes.
Under the election rules.
Well, this is a very interesting subject. Lordship can give us some more time, Millard. We will also try to assist your Lordship. Let my learned friend also. Negi.
Right
But
now, I
you
can
just
point it
have
out.
a impression of what he would like to
I
argue.
can right now point it out. The answer is under Rule 13 of the election rules.
13 of the election rules. Where do we find
If
it?
I am not mistaken, by the way.
Your Lordship's kind permission, can I take leave? Millard? Deep.
Election rules 13.
Number of valid nomination paper is equal to total number of members to be elected to the board of directors. Returning officer shall declare such candidate to be duly elected to the board of directors. Now, 13(1) says where there is no requirement of election.
This is not helping you because it talks of when the number is equal or more.
Right.
Nothing provided to say when the number is less.
No, 41(9) is there. I have already pointed out.
41(9).
41(9).
41(9), what does
Yes.
it say?
41(9). Where there are vacancies in the office.
That is what?
Yeah.
Once you have 15 persons, the board is constituted. If you have lesser than 15 numbers, the board is not there, is what is trying. The board not being there, someone holding the post of a director in that board cannot be there. So none of them are directors. Because the board is not there. That is what it will lead to. His argument, if we go step by step,
Yes.
ultimately the argument will fall down to the position where there is no director because there is no board.
Because then, my lord, again, it will beg this question.
We are not
Well-
saying he is correct or he is wrong or nothing. We are not on
Exactly,
that.
Lord.
What we are trying to find out is there is an argument.
Yes,
We
correct.
will have to answer it.
Correct, my lord, I have to answer it
So I have
because
to-
your lordship will see,
Hmm.
if we go by the entire scheme, what the scheme says, that before your expiry of your term, you hold the election. This is the mandate, my lord.
Done.
Now, the question which is, my lord, which will beg is whether short of 15 members, the board will wait, my lord. That was my first argument, my lord.
Whether there will be a board
Whether there is
short of 15.
Yes. Now, your lordship will kindly see, before the term is expired, suppose my lord today,
Hmm.
term will expire.
Hmm.
So the the new board has to come, my lord, today or tomorrow. Now the arrangement has to be done, my lord, prior to that,
Yeah.
15 days, 30 days back,
Yeah.
15 days notice is required for election. Now, my lord, if 15 numbers of, my lord, nominations are not received,
Hmm.
whether the, my lord, board will go for the.
Say in a situation,
Yes.
no nomination is received for whatever. If we answer something in law, if we lay down the law that this is how it has to be,
Yes.
we have to take into contemplation all the situations that may arise.
Correct.
So now there is no nomination in a case, or there are 2 or 3 nominations. Now there will be 3 directors, and the board which was required to hold the election, they have
That
done
has-
their part.
No, that has to be tested with quorum. Unless, my lord, there is a quorum, the constitution cannot be said to be invalid.
So therefore,
Because-
with 3 directors, it
Yes.
has to go.
Has to go. Absolutely correct, man. It has to go.
Yeah.
But your lordship will see 41-6. It makes it clear.
What happens if it is 7?
Then it can
No,
go.
go for 6.
Your lordship will.
So
be-
you are saying that if more than 5 members are there, the board is constituted.
the
Can it-
co-option, the
Co-option will come with 6 plus 3.
6 plus 3.
So anything above 5
Yes.
will form a board.
Form a
So
board.
six persons sitting there can form the board of directors.
They can form the directors because your lordship will see, essentially, under the
But
scheme.
it cannot be below the 50% is also the mandate of law. That is what we will have to see.
Yes.
So if you and I keep discussing in the absence of the senior counsel, who
No,
was
no,
allowed to
correct.
proceed on
Lordship will fix it
this one, but
some other day. Then,
but this angle, if the question is raised, I have to answer.
no, correct.
That is
correct. I have to assist your lordship, ma'am.
not raised, not answered is good enough.
Your lordship, the question which is troubling your lordship is whether 15 can form the board or not.
Whether
Whether less
anything
than 15
below
can-
15 will form the board or not, whether for the bylaws, it is mandatory that only when 15 elected persons come together, the board is formed. And once the board is formed, whatever you do after that, quorum, co-opted, whatever is the law follows. But when your bylaws say, which is not contradicting the act, provisions of the act, that 15 members will form the board.
Correct.
So we will need 15.
Correct. In that line, I'll try to satisfy.
That thing we have to trace out all the situations that may arise.
Well.
2 or 3 situations came from me. Other situations may also be there. One is already before us, 11 members, whether the board is. We have to answer that, and
Yes,
we
yes.
don't want to give an answer which will go half through.
Right.
Halfway will not help,
Correct, correct.
because this will be sometimes, this will lead to the interpretation. Okay. Heard Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr.
P. Gayon.
Learned counsel appearing for the petitioner. Also heard Mr. S. K. Talukdar, learned counsel appearing for the Cooperative Societies Department. And
for 6
for 6 to 13 P. Hazarika. Okay. The matter has been heard at some extent, and both the councils have sought for some time to address on an issue which came up during the hearing and may have a bearing on the interpretation of the provisions of the bylaws and the acts. Allowing such time, list this matter again after 2 weeks on a date to be fixed by the registry for further hearing.
Correct. It's an interesting point, Pala. Correct. Obliged, Pala.
You would like to take this back and give it to us on the next. Yes, Nitin?
But in this case, respondent standing counsel AFDC, as per my information, he is not well, my lord. He's,
Oh, Mr. Pisham.
Yes, my lord. Otherwise, biddings are complete, my lord. Let it be fixed within the last part of November, my lord. The date.
The subject matter is what?
Regarding non-payment of amount, which the petitioner was appointed as an inquiry officer to conduct a departmental proceeding on behalf of the fishery AFDC.
You can wait for 3 weeks.
Not 3 months, my lord.
3 weeks.
3 weeks. Yes.
We are taking a chance. If it comes up before the vacation, we dispose it of. If we cannot make it, we keep it immediately after the vacation and
Yes,
because matter is of 2022.
yes, date may be fixed, man.
We'll fix a week.
Week.
Last 2 weeks would be perhaps, or last week maybe a motion week, the usual procedure. So we'll keep that week out. Mr. D. Chaudhary, Learned Counsel, appears for the petitioner. Full stop. He has submitted that the pleadings in this matter are complete and the matter may be taken up for final disposal. So, however, due to the inconvenience of Mr. P. Sharma, Learned Standing Counsel, AFDC.
It is my knowledge from knowledge I am serving.
He has submitted that the matter may be taken up after 3 weeks for disposal.
At the admission stage.
At the admission stage itself, the matter is of the year 2022. Stop. Request is allowed. List this matter after 3 weeks on a date to be fixed by the registry in the admission column, on which date a attempt would be made to dispose the requisition.
Oblige.
A teacher. Teacher भी करना होगा. Could do 5 to 7 years.
Well, you can make some query on the strength of the submission coming from the Council of Water Resources. There is a case in these 3 petitions. Lands were acquired under Section 9 of the 1964 Act, invoking the emergency clause. Because of the reason, my lord, that for flood control and other things, my lord, land has to be quickly acquired. Now, once the lands are acquired, definitely, my lord, the funds will be earmarked by the controlling department. That is, my lord, the Water Resource Department. Now, this instruction was placed. There is a case, my lord, where they have not received, the petitioners have not got the land acquisition compensation. Now, they say, my lord, that a file has been submitted to Judicial Department. Perhaps because of the reason, which appears, my lord, to me, that whether those land acquisition proceedings were, my lord, exercised or conducted in accordance with law, and my lord, from what head of account the money will be dispersed, perhaps to that extent, because I am not in.
When was the land acquired, sir? The writ petition came up in 2022.
On 6/3/22, Lordship, the work started, Lordship, the construction work.
3 years down the line, these people are being deprived of their land.
My lord.
3 years now that these people have been deprived of the land, deprived of the money.
Now, my lord, what has happened here, my lord, seeking the funds, necessary funds, the Water Resources Department had communicated to the Finance Department seeking funds for sanctioning of funds. Now, Finance Department found that the proposal was not within the benchmark. Several, my lord, informations were lacking. Now, the court.
In September 2025.
Yes, so those things were reverted back to the Water Resource Department to mention the court case order, because, my lord, the orders have to be there, my lord. If a litigation is pending, because if a litigation is.
So why don't we let the department sort out everything within yourself at your convenience? Please give the land to the petitioners to be used by them till then. Can it be done?
That perhaps, my lord, it is not possible because land has already been taken possession.
This is what I'm saying, that
Now, my lord, the difficulty is that.
when the land is taken, it is by the mighty state. And when the process is done, it is being done by the mighty officers, sending the file round and round and round. Objections raised, if any, shall be done, should be done at a go. Met at a go. Finished at a go. One objection, send it back. That comes in. Another objection, send.
No, my lord,
That is what is happening. Now they are Now perhaps the finance is asking for the judicials.
Because my lord, then, my lord,
Along with the judicial view should have been the first step that you correct this part and send it along with the judicial view which is missing. Can it be done in a stepwise manner when someone has been deprived of his
People kindly,
land?
kindly appreciate the situation. Here is the case where, my lord, we are at the stage of sanctioning of funds. The funds have to be sanctioned, meaning thereby it has to be earmarked. If no funds are available, supplementary demand will have to be made before the assembly. All these things have to be taken care of by the administrative department concerned, that is the water resource department. What they have done, they have straight away made a proposal to finance. Finance didn't got any head or tail of that proposal. So therefore they were advised, kindly take the views of judicial department and along with for what matter it, for what
Now,
purpose it is required.
your submission on the 18th of September, Sri Arbur Pujari has submitted that in view of the above, the grievance of the
No,
petitioners
yes.
can be addressed.
I had a discussion with my lord. It was under misconception
There's some
because
misconception, your
because
lordship.
why I made that submission, my lord. Some other writ petitions are also pending. Those writ petitions are now disposed of. There was a confusion, my lord, on
Yes,
the
your
part of the standing council of the water resource department. She mixed up everything. So I said that, my lord, with regard to those. writ
Now, this judicial department,
Yes. Now, unless and until these things are not placed before the finance department, I am the custodian, my lord, of all the funds. I cannot release the
Ca-
funds, my lord. It is public money.
can we have an assistance as to, they must have had the, they must have the documents in the records with the finance department must have it.
No, my lord, it is the water resource department.
No, they sent you a proposal. So our copy must have been written by you at some.
Whether it is online, nowadays it is online.
So
Therefore, these documents which I am carrying, which has been placed to me right now, my lord, this is the online. This is now done online. That's the difficulty.
So the records are not maintained online.
So records are there, but it has been reverted back again to the water resource department. They were directed, kindly take the views of the judicial department, complete the proposal in.
So
all
when did
particular-
you send it to the judicial department?
Yes.
Lordship, I had immediately after finance query, I have received on 3/9/25, your lordship. Immediately thereafter, we have sent the file to the judicial department.
See, your instruction which you have given, the 6th of November instruction,
No, they don't, it does not reflect anything, your lordship.
no, it reflects that the Morigaon Water Division, Water Resource Division was submitted to the Judicial Department by file number 663-644.
Hmm.
Now, this does not say when.
Yes, your
You are,
lordship.
yet you are saying immediately.
Because your lordship, court order reflects that we have sent it, earlier submission also made.
So Judicial Department is causing some delay in the matter.
Yes, because till then
Who
file is
appears?
pending.
Who appears for the Judicial Department? Standing Council in a government of some. At 2, can you find out what has happened to this file number? There's a file number. You just have to tell us what has happened to the file number. At 2 mato. At 2. Kindly take the details. When was the file received by them? The officers who are handling the file and what has happened as of today.
Obliged.
Obliged.
I will oblige.
Item 14.
That's all. It is already over. Matter has become infructuous.
What was the phrase?
It's from 2024.
You are appearing for the
PNRD lodge.
this is item number
14.
14. We'll keep in mind that it is in front of you have made a submission.
Lodge.
Let us see if someone from the
Last of it, lodge, they have not been appearing. Petition.
on the last occasion,
On last
someone-
dates lodge.
someone made a request for a week. কোন বিষয় মেটান আহিছিলেন এখন আপনি এটা স্কুল দি থাক আইটেম স্কুলটা দি থাক নেক্সট মাহতে অর্ডার করতে Revenue Department, who appears? This perhaps is a matter where they are asking whether ex gratia receivable on account of a motor accident, death and claim before the tribunal can be interpreted to mean that the quantum of compensation receivable under the ex gratia scheme would be deductible from that.
Yes.
When someone receives an ex gratia
Yes.
for death, and then the motor accident claim tribunal also makes a also grants compensation, whether this money will be deducted from that claim.
Whether it will be
Set off
adjusted,
whether it is.
prima facie, it may amount to my lord double benefit.
But now there is a judgment which says that if you are going under the MACT, then the ex gratia is not applicable. And if the ex gratia is there, that means the motor vehicle is not identified, so no claim.
So, Honorable Mr. Justice Surana.
Justice Surana.
Osina Khatons. Yes, Lordship.
So now
Yes.
this has to be reconciled.
Yeah, that has been, my lord, put to appeal before the division bench, and that appeal is pending, but nonetheless,
No,
my lord,
that is not affecting it here. That is just one passing thought that now
No, my-
ex gratia will
correct.
not be and will not be given when there is a MACT claim.
MACT.
Or when there is an ex gratia claim, there cannot be an MACT because the vehicle is unidentified.
Absolutely.
Here, they are asking for 2 lakhs
2 lakhs under the notification,
ex gratia.
ex gratia. That notification lordship will file, my lord.
But
at
they
page
have also, I think, approached the MACT. Because there is a police report. If that be so, then Justice Surana's order would cover.
Yes. That will cover.
Where is that police report?
Well, the postmortem report, lordship will find it at page 16, my lord.
No, the
1/6, postmortem report.
whether the truck was identified.
Yes,
If not, then the 2 lakhs is entitled to.
yes. Now, my lord, lordship may be pleased to kindly come to, my lord, page 27.
27
Page 27, this is the notification. This is the
of
notification, my lord,
2014.
2014. Now, this has undergone an amendment, my lord, in the year 2023.
Uh-huh.
To the extent, my lord, therefore, my lord, in Justice
They will
Surana-
not get it.
Yes, honorable court has taken into consideration of that amendment, that only in hit and run case,
Yes.
where the vehicle cannot be identified, and one cannot, of course, my lord, inevitably, one cannot lay a claim before the MACT. Vehicle has to be identified.
It has to be identified.
So it is a natural corollary, my lord. So therefore, under that circumstances, the person concerned, the victim will be, my lord, entitled to the amount of rupees 2 lakhs. Now here, my lord, this fact, my lord, whether the vehicle has been identified or not, my lord. to
It
the-
has not been identified. The police
Yes.
report says that there is was a hit and run,
Yes, my lord.
page 14.
Page 14, my lord. Yes. So perhaps, my lord, to decide this writ petition, my lord, an affidavit, my lord, from the district commissioner will be required on facts.
It says, madam, the query has been taken place. Sanction amount has not been decided.
From whom?
From the land revenue.
To identify funding.
That part of that part, whether he's entitled under the memorandum or not, is not settled. If
Is
the
settled.
vehicle is not identified, and when they are saying that the sanctioned amount has not come, so he is entitled under the
Perhaps.
memorandum. Now you have to pay.
Because that instructions I have also seen, my lord, there, my lord, the vehicle number is not, my lord, identified.
Really said, this is of 2023, this instruction.
And therefore, my lord, perhaps an
And a
affidavit
matter of facts.
from the, my lord, police authority
To,
concerned will be required here to
so,
find out at least whether
could it be so that if this document,
my lord,
if this Paravise comment is supplied to you also, perhaps the fresh sanction, the fresh proposal has to be there for payment in this year.
no, my lord, that is true, but here, my lord, what I am clinging on is on the aspect of identification of the vehicle. Lordship has seen that instruction. And in the writ petition also, my lord, no detail of the offending vehicle is available in the writ petition. So therefore, under that circumstances, since my lord, sufficient time has elapsed in between, perhaps an affidavit, my lord, from SP Lakhimpur may be called.
That would be upon the Department of Revenue.
So revenue
To take the
department,
details from the police station. Why should the man run around?
no, my lord, why I am making that submission, my lord, let the affidavit be filed, my lord, by the SP Lakhimpur. SP Lakhimpur is a party respondent out here. Respondent number 4, my lord. R4 is the SP Lakhimpur. Now, so far as revenue department is concerned, under the scheme, my lord, all the verification exercises has to be done by the district commissioner, everything. The revenue department is only the sanctioning authority.
Okay.
So it is
None appears for
practically the district commissioner, my lord.
then none appears for the petitioner on call. This writ petition had been instituted praying for a writ to the respondent authorities, directing them to pay the ex gratia amount of rupees 2 lakhs after due verification, as per the notification dated 15th of November 2014. Since the husband of the petitioner had expired in a hit and run case, a hit and run motor accident case. Full stop. The case was instituted in the year 2023. Full stop. Notice 2023 and the notices were issued on 16/10/2023. Full stop. Today, when the matter is taken up, a parawise comment submitted to the learned government advocate by the District Commissioner Lakhimpur on 11th of December 2023 has been produced, which says that the circle officer Nauboisha Revenue Circle had submitted the proposal for disbursal of ex gratia amount to the petitioner, and the said proposal had thereafter been forwarded to the government in the Revenue and Disaster Management Department by letter number. He will keep this for some time. He will note down the number. Then give it. Mark if like on the Nila. Dated 1/12/2023 for sanction of ex gratia amount for payment to the next of kin of deceased late Pradeep Puragohai. Full stop. There appears to be no updated instructions thereafter. Full stop. Mr. Arbor Pujari, learned counsel appearing for the Department of Finance.
Appearing for revenue.
Appearing for the Department of Revenue has submitted that it has also to be verified as to whether the husband of the petitioner was a victim of a hit and run case where the vehicle could not be identified, and therefore appropriate instructions have to come also from the respondent number 4, that is the Superintendent of Police, Lakhimpur, not Lakhimpur, Assam. You would represent him also, sir? Yes. the learned government advocate appearing in the matter. So and so Mr. Government Advocate appearing in the matter shall inform this court on the next date of listing the shall have appropriate instructions from the Superintendent of Police, Lokhimpur, not Lokhimpur, and the District Commissioner, Lokhimpur, not Lokhimpur, as to whether the husband of the petitioner have suffered in a hit and run case by an unidentified vehicle or not, and if so, what further steps have been taken by the district authorities to process the claim of the petitioner after 11th of December 2023?
Hopefully, SP will have got nothing to do. It is a what proceeding place?
SP will tell whether it was an identified vehicle. If so, the district authorities will inform you as to what further steps have been taken after 2023. Yes, they sent a proposal.
That will be my revenue department.
They sent a proposal. Nothing happened thereafter.
Revenue department.
Yes, tell us that it was by an unidentified vehicle.
SP will do.
Tell us that the proposal which can now be considered by the finance has been given to the revenue. Mr. Borpujari is here for the revenue and the finance. Is it not? They will again need a sanction for it. So unless your proposal which can be considered by the finance department for the current financial year goes, 2023 proposal is not going to do anything. Even if it was sanctioned, it has lapsed. These are things if we keep on saying for time. Yes.
Sir, why I have made that submission? Because of the fact, my lord, in the police report itself it is stated that the case ended in search sheet. If there is a search sheet, definitely, my lord, some persons have been, my lord, booked. Page 14, 1/4, page 14. The time, my lord, the handwritten copy is at page 15, 1/5. The last line, the last word. Kindly see, my lord, kindly see. It is in charge now Boisa police outpost.
Or can it be this way, since none appears for the petitioner? We close the writ petition.
Yes, my lord, if it is, vehicle is not identified, my lord, then he will be entitled.
Requiring the who has to pay that? The circle officer will make the
District commissioner. Under the scheme of the notification, it is the district
the
commissioner.
district commissioner will make the inquiry if it is a case of hit and run by an unidentified vehicle. Appropriate steps be taken within the next 2 months. And if it is an identified vehicle,
Yes.
judgment and order passed in that case would cover this case also.
Yes, that cannot.
None appears for the petitioner on call. Heard Mr. Arbor Pujari, learned counsel appearing for the revenue department, also counsel appearing for the respondent number 345 full stop. The prayers made in this writ petition is that the petition is that the husband of the petitioner had succumbed to injuries received in a road traffic accident within bracket RTA, within bracket RTA, on 15/12/2008 at Pohumora Daily Market under the North Lakhimpur Police Station in the district of Lakhimpur, Assam. In this regard, North Lakhimpur Police case number 815 of 2008 under section 279/304 within bracket capital A/427 IPC was registered. And after investigation, the case culminated in a charge sheet being submitted to the concerned court. Full stop. The petitioner, who is the wife of the deceased, has prayed for being granted the ex gratia amount of rupees 2 lakhs under the notification dated 15/11/2014. Full stop. Mr. Arbor Pujari, Learned Counsel, preparing for the Revenue Department has submitted that since the matter has admittedly ended in a charge sheet, it cannot be a case where the offending vehicle was unidentified.
My lord.
Full stop. He has further submitted that this court in by its order dated so and so in WPC number so and so has held that it is only in cases where the death occurs due to a RTA involving an unidentified vehicle that the next of kin of the deceased would be entitled for payment of ex gratia under the office memorandum dated 15/11/2014. Full stop. Although this court is inclined to dispose of the writ petition in accordance with the judgment and order dated so and so, passed in so and so supra, comma. In the absence of the counsel for the petitioner, this court has not been able to ascertain as to whether the offending vehicle had in fact been identified or not. Full stop. This writ petition is therefore disposed of, directing the respondent number. District Commissioner is respondent
Number 3, my lord.
Three. That is the District Commissioner, Lakhimpur, North Lakhimpur, Assam, to verify as to whether the husband of the petitioner had expired as a result of the injuries sustained in the RTA by an unidentified vehicle or not, and whether the provisions of the office memorandum of notification dated 15/11/2014 would entitle the petitioner to be paid the ex gratia amount. Full stop. Since the matter relates to payment of to a decision on the ex gratia award to be amount to be paid to the petitioner, comma, the respondent shall cause the inquiry and pass final orders within a period of 3 months from today, comma, with a copy of the inquiry and the order to be endorsed to the petitioner at the address given in the writ petition.
The case number is WPC 2700/2023. Date of the judgment is 21/6/20.
Mosina, my lord.
Mosina Khatun.
Mosina, Monisa Khatun.
Monisa Khatun.
Monisa.
Monisa alias Monisha. I think that is the name.
Yes. There is one other aspect of the matter, my lord.
Yes.
I should point it out, my lord. In that notification of 15 November 2014, there is a condition, my lord, that the incidents prior to 15 November 2014 will be governed by the OM notification relevant to the period. Earlier, it was, my lord, 1 lakhs. That notification is also a part of the.
There is a judgment of
That
this
will be
court.
taken care.
There is a judgment of this court which says that if the entitled ex gratia is not paid within the period of subsistence of the earlier office memorandum and is being considered at a later point of time when a new office memorandum comes, nothing will stop the payment of the ex gratia under the new.
That can be.
Yes, that we do not want to decide now.
Fine.
Yes.
I'm obliged.
Disposed.
In this case, your lordship, after I file my writ petition, your lordship, there are certain developments that have taken place, your lordship. Now, one development is that, your lordship, the election of certain candidates, your lordship, to the board of directors, we have put to challenge, your lordship, in an election petition before the election authority, your lordship. That was dismissed. Then we came before this honorable court. In the meanwhile, since there was no interim order passed, your lordship, in the meanwhile, the new board has also been dissolved, your lordship. Now, one-man committee is, your lordship.
We don't want a one-man committee running a
Lordship,
cooperative.
election, your lordship. Only thing, your lordship, that I just want to take instructions from my client, your lordship. If they are agreeable since your lordship, our case was that 3 of the elected members, your lordship, of board of directors, they should not have been, your lordship, allowed to participate in view of your lordship, by operation of law, your lordship. And
Those are objections which will come before us or before any other forum once those 3 persons now try to contest an election and you have some objection to their candidature
lordship,
being accepted.
lordship,
As of today, the candidates against whom you had objections is already dissolved. That board is dissolved.
that is dissolved.
So now when nothing remains, let a regular election
No,
take
that
place
can be, your
and
lordship.
any of your objections to any of the candidatures will be processed in accordance with law.
Only-
You making whatever objections.
That
is it.
what has fallen from your lordship's mouth is absolutely correct,
Ah.
your lordship. Only apprehension is, your lordship. Since already there is a, your lordship, order passed by the election authority, the RCS, your lordship,
Ah.
is the capacity.
That was with regard to that election.
Lordship,
It cannot-
that observation, if
It
your
cannot
lordship
govern
can-
the new election,
Lordship.
can it? It will not govern any new election petition or any new objections that may have. And if it is already a res judicata,
No, that's why, your lordship, that's why, your lordship, if that comes in by way of challenging that, your lordship, that is the only apply. If I can take instruction from my client, that in the new election,
no, we
everyone
can observe that if there is if a new election is commenced, of course, all objections to any candidatures or any other procedure of law will be taken up on its own account.
My lord.
Without reference to to any of the adjudications made in the earlier round of litigation.
Lordship, that
we
will,
can say,
lordship.
and then we can close.
Earlier order passed by the, your lordship.
No, we will say it will be taken up afresh without reference to past litigations
My lord.
regarding the earlier elections.
Lordship, lordship. In that case, your lordship.
What do you say, Mr. Talukdar? Is it?
Correct, my lord, but only one aspect of the matter, because.
No, we can
once-
take it up on merit. We can decide whether the
No, my lord, your lordship.
tribunal is correct or not.
Yes, this proposition is, my lord, agreeable to all, but only one aspect of the matter, that the consequence, my lord, will follow in accordance with law. Why I'm saying so? Because once, my lord, a disqualification is incurred, that remains up to 5 years in terms of the act. So once, my lord, the director has incurred disqualification, irrespective of the election, first election, second election, third election.
He had challenged someone's candidature.
Yeah.
That candidate, that challenge has been not entertained by the
Yes, ma'am.
tribunal. Now, when you are going for a fresh election, we do not see why you have an apprehension that he may be suffering a disqualification. That
No,
was
I-
never an
I'm
issue before
not-
the tribunal or the disqualification of any other person.
Yes.
That was never an issue.
Yes.
The issue was his challenge to the candidature of some other.
Yes. So far as Bothagur is concerned, my lord, he's. not
Any other
required to-
person
He's
coming
not
up who is not
suffering.
eligible,
Yeah.
they will have their own objections, you will have your own
Yes, yes,
decisions.
correct, correct.
Whether consequences will follow or not, consequences of
What
what?
I'm trying to say, my lord, the judicial order, my lord, should be inconsistent with, my lord, the mandate. Because the moment your lordship says that the new election, but it's a new election, so earlier disqualification, my lord, will not come into play. Perhaps.
So the board has been dissolved. So what do you want to
No,
know?
there is no disqualification at all. That is what we had put to challenge, your lordship.
When there is when the board has been dissolved,
Yes.
then what will happen now? Continuation of the earlier election.
No, no.
Then they will be the only members. Unless it is a fresh process.
Yes.
Will you have new candidates coming in or old
Correct,
candidates
correct.
moving out? It cannot be. It has to be a new process.
New process.
And I don't think the department is
Correct,
going to slice up every word that we say in
No,
order to
Correct.
find
Well,
out meanings. and how
One-man
it can
committee,
be.
one-man committee cannot run for indefinite.
That is what.
Yes, your lordship will say, well, press election, and whatsoever the objection they have, well, they can, submit
take them.
My
in
lord,
the
only
appropriate forum.
liberty may be granted to participate in the fresh election, my lord. Since
In
we are-
accordance with law, whatever
accordance
limit
with
you have it under the law.
Yes,
since there is
correct.
a bar, my lord, after disqualification.
Then we'll take it up. Then we are taking up for this proposal. Yes, let's start. We'll go by merits. We'll go for this.
Accordance with
Yes,
law
sir.
বুলি ক'লে তোমাৰ চব সোমাই যাব, তুমি চাই লোৱা। কি কৰিবা?
Accordance with law, ক'লে হৈ গ'ল তোমাৰ। Yes.
Where is that order which is under
21
challenge?
এইটোতো হেৰি হৈ যাব বাৰটো আহি যাব
Your lordship want to take up my case or his,
Whichever.
তোমাৰটো কৰি লোৱা। I am agreeable to now your lordship to election, your lordship. Since he is raising a grievance, his petition may be taken up first.
It is passed, my lord, in accordance with law, my lord, then.
That is what the
That is what
Honorable Court
Honorable Court is saying.
See,
He has no objection.
there are two things. One, we can hear you, and one, we can listen to you. We would like to hear. That makes more sense. We are even listening to the keyboard being typed. We are not paying attention to them. Making a submission which end of the day will come down to something. It only wastes precious time. Otherwise, anything on merit or on law, if you want to submit, this court will hear you fully. Fully. In details, we will hear you. Every submission will be taken into account.
Remand back the matter, my lord, for fresh election, my lord.
So what we say is that the issue which was in this petition, the election of the persons of the election process, which was taken up in the election tribunal, has that board has now been dissolved, and therefore the necessity has arisen to go for a fresh round of election. Therefore, these petitions are closed. The respondents are now directed to take up the fresh process in accordance with law and within the limitations as prescribed by law.
My lord.
And we will make it clear that nothing has been adjudicated in this situation to the detriment of any of the parties.
Correct.
And your lordship giving us liberty to raise the issues before the competent authority or
Any fresh issues in the
My lord.
Irrespective of your lordship's observation, they will have the liberty.
Yes, heard
No,
Mr.
that
S.
is-
Bhattakur, Learned Counsel appearing for the petitioner, and also heard Mr. Yes,
My lord, S. Ardurika,
appearing for the
Uh,
petitioners in WPC.
WPC number 1514-2025.
Good stuff. The grievance raised in this writ petition by the petitioners was in relation to the order dated 14/11/2023 passed by the Registrar Cooperative Societies Assam, and also the approval granted by the competent authority to the election to the Board of Directors of Messrs. Dhupaguri Samobai Samiti Limited, Nagaon. And prayers had been made to direct the respondents not to allow the new Board of Directors constituted after the elections held on, can I have the date of the election? Elections held on
My lord, 17/9/2023.
17/9/2023. Full stop. Any affidavits filed?
Yeah.
You have not filed your affidavit, Mr. Talukdar?
My lord,
You have not filed your affidavit?
yes, my lord. In fact, the subsequent development having taken place, my lord, in the Bhattakur's matter, affidavit not filed.
After the matter was heard at some length on 30/10/2025, the learned counsels appearing for the parties had sought for some time to take instructions on the recent developments. Full stop. Today, this court has been informed that the Board of Directors, which was under challenge in these two petitions, have also been dissolved for reasons different from what was agitated in this writ petition. However, in view of the dissolution of the Board of Directors, a necessity now has arisen for conducting of a fresh process for election of the members of the Board of Directors in the cooperative society concerned. Mr. S.K. Talukdar, Standing Counsel appearing for the cooperative societies, who was Cooperative Society Department, has submitted that the department is not averse to initiating a fresh process for constitution of the board of directors in accordance with law and within the time frame as prescribed in law. The learned counsel for the petitioners in both the writ petition also consent to such a process being undertaken, provided that they are and pray that they are given the liberty to raise objections in such process if so required in accordance with law. Full stop. In view of the consensus arrived at between the contesting parties, the other parties have gone unrepresented. Other parties. Notices were not served.
Notice served, Your
Notice
Lordship.
served.
Notice served.
Just prior to that sentence, you read, the respondent number 7 to 16.
16, Your Lordship. Like
Almost
it.
served.
I'm representing 8 and 9 in the method by seniors repetition.
Okay, although where served notices, comma, only respondent number 8 and 9 in WPC number 7439 of 2023 are represented by Mr. So-and-so, who also represents the petitioners in WPC number 1514 of 2025. Full stop. In view of the consensus arrived at by the contesting parties, and in view of the necessity arising for conduction of a fresh process for constitution of the board of directors, this writ petition is disposed of, directing the respondent authority, namely the registrar of cooperative societies. Huh? And any other authority needs to be directed, no?
No, register of cooperative.
Registrar of cooperative societies to take appropriate action in accordance with the relevant provisions of law. Forthwith, to ensure the constitution of the fresh board of directors of the cooperative society concerned. Full stop. Needless to say, since a new process is being initiated, the parties to this, the parties in this writ petition would be at liberty to raise such grievance before the appropriate authorities, if so required, in accordance with the provisions of the
Law
Cooperative Societies Act and what else?
and the election rules.
And the election
Election
rules.
rules.
Full stop. Writ petition accordingly disposed of, no order as to cost.
One observation may I
Yes.
make, that Your Lordship, while deciding the objection, they will not be influenced by the earlier order.
In case of this, in case any objections are raised by the contesting parties to the fresh process to be adopted for constitution of the board of directors, the appropriate authority deciding such grievances would not be influenced by the previous litigation with regard to the earlier election process, which resulted in a board of directors which now stands dissolved.
Deeply obvious. Deeply obvious.
Yes. It is disposed. Huh? Do you have a petition disposed?
May I please your lordship?
Yes.
Lordship, I'm the new counsel. I have filed my wakalatnama yesterday.
Yeah.
My learned colleague was the earlier counsel. He probably prayed for striking off his name. And my name is not.
The striking of the name would be perhaps with an application made to the court. That perhaps is the requirement of the Guwahati High Court rules.
Yes, sir.
Whenever you have an wakalatnama on record, if you want your name deleted, you have to make an application. We can allow it. Yes.
My name.
Are you ready or do we?
No, my lords, I've just got my record yesterday. My lords,
Have you filed your wakalatnama?
Yes, my lords. Yesterday I filed a wakalatnama.
Mr. So-and-so, when a counsel appearing for the petitioner has submitted that he has been recently engaged in this matter and would require some time to go through the records so that he may address this court stuff. Although the notices in this case was issued on 5/1/2024. Mr. Hendik,
Lordships.
apparently there was some grievance regarding the registration of a Khula Talak.
Lordships, Malad, this is regarding
And then the orders passed and the notices issued which have been exceeded in the writ petition are no longer in force because the governor of Assam has- government has withdrawn everything by an appropriate
And
notification.
even the Lordship, Malad, can you see the marriage?
Hmm.
There is, Malad, they have an agreement before the notary that marriage has been solemnized.
Well, that is the procedure in the Mohammedan law, my lords.
Malad, that is not
Before
a
the
procedure.
notary.
How can
Yes,
Malad?
Malad.
You cannot rule out the notary. Even he is a witness to a marriage.
Yes, my lords.
What bars from a notary
unlike-
from being a witness to a marriage?
Even when the Kazi, Malad, marriage was in the Malad that in the Kamrup district, the divorce was filed before the Malad that.
You want them to stay married? You want to say that their marriage did not exist? They should stay married or the Khula Talak should be there? You have to take one stand.
My lords, if I may point out to order dated 25/2024, my lords.
That is what I'm saying.
Yes, my lords. So basically, my lords, the question is this: unlike in Hindu law, where this is marriage is called as sacrament, this notary, which has been now raised by my learned colleague, my lords, this stands valid in the eye of Mohammedan law in the personal law, my lords.
What is said here is that
Yes, my lords. Now the question
everything has been rescinded by the government.
But from my limited understanding, I'm not sure, I have not gone through so much, my lords. Therefore, my lords, if my lords, their objection with regards to maintainability, if that can come in a form of an affidavit, my lords,
Your prayer is that the Khula Talak should be there or should not be there?
should not be there because
Should
my
not be
lords,
there.
that-
You
that
should
is
be
legally, yeah.
you should be understood to be married to that person and this
Yes, yes, my
talak
lords.
should not be.
Now they say that now that is rescinded
Let
by
him be
the
happily married. Let him take
We
the-
have no objection, Malad, if they are remain.
No, my lords, but the problem
Even
is-
then, Lordship, the Kazi is no more in Rana now.
Therefore, my lord, the appropriate would be the now the district registrar.
District
You know,
registrar,
all that my lords, since I have not gone through the file so much, my lords, all that my lord will pray that if they can form an affidavit to, if they have a question with
Affidavit
regard to
not
whatever,
required,
my lords,
Lordship. Affidavit
because
not
they have said
No,
that, my lords,
since the councils are saying that the affidavit would not be required, you would argue on the next date, they would make any submissions they have on law without controverting the facts. We'll decide the matter. And has been recently engaged in the matter and 5 days wakalatnama today. Instead of be placed for some time to prepare the matter. Stop allowing the prayer, list this matter again after 3 weeks on a date to be fixed by the registry. Respondents would be at liberty to file their response to the writ petition.
I'm so obliged, my lord.
24, 25 by the AC to the wrong Yes.
I'll be affidavit in opposition.
You are for the respondent number?
I am for the water resource department, my lord.
When did you file it?
21, 2025.
My lord, 21 July 2020.
20th of
Because July-
January 2025.
July 20.
January, the respondent number 4 files it
On behalf of the,
in January
my lord, on behalf of the department.
on behalf of everybody.
Not
Cannot
in
be
July,
July.
21,
July.
2025, my lord.
Huh?
21, 2025, my lord.
21, yes, I'm saying January. It was filed in January. You don't need to file a reply.
One in July.
No, my lord, in another matter, in 25, my lord, item number 25, my lord, they have filed on affidavit on
That is in July.
Okay.
21st July.
July 2025.
Okay. So you would like to file an affidavit or no?
Yes, my lord,
A reply?
reply.
What is the matter regarding?
My lord, this matter related to land acquisition matter, my lord. My lord, that land was acquired by the respondent authority in the year 2021-22, my lord, without any notification, my lord. After that, the court direction, they have filed joint verification report and admitted in the affidavit, my lord, that that land was acquired by the respondent authority without any procedure, my lord. But in the affidavit, my lord, they made a award, my lord, which was wrongly calculation, my lord. So I'm going to file affidavit.
Then please ensure that the affidavit in reply and both the repetitions are filed. So then
My lord, item number 25, my lord, 149.
24 who appears?
No, I think 24, 25. No?
You are appearing in both.
In both, my lord.
So you want to file an affidavit in
In
reply
reply 25, my lord.
and what about 24? Not
And
necessary.
they filed affidavit, my lord. In that affidavit, they admitted that land was acquired, my lord,
Hmm.
without any notification, and they prepared a award, my lord, but which was wrongly
Without notice.
calculation. Yes, my lord. In second item, admitted already.
Permitted.
Their name is not found when it is 2013.
Huh?
That is the problem. It's old method.
Okay, it has been submitted by Mr. P. Saikia, learned counsel appearing for the Department of Revenue that an affidavit has
No,
been
I'm
filed.
water research
Water Resource Department that an affidavit has been filed
import method.
in WPC 1490 of 2024. And the learned counsel for the petitioner on such submission has pledged that she may be allowed 2 weeks time, 3 weeks, 3 weeks.
Under 2 weeks, my lord.
2 weeks time to file the affidavit in reply to the affidavit in opposition. Both these matters relate to land acquisition without notification or notice of award to the petitioner.
Yes, sir.
Full stop. List these matters again after 3 weeks on a date to be fixed by the registry along with the affidavit in reply proposed to be filed by the petitioners. An attempt would be made to dispose of the repetitions on the next available date. Come prepared, we'll try to dispose it of. If there was none appears for the petitioner on hold today. On the earlier occasions also, there were several instances of absence of representation. On 19/9/2025, this court had observed that in the case of default, appropriate orders would be passed on the next day. Sir, it appears that the petitioner is not interested in pursuing the cause. Accordingly, this writ petition is dismissed for non-prosecution.
Item 5 to 7.
For the instruction, my lord, it was received by the judicial department on 29/2025. And my lord, the concerned officer received it on 17/10/2025. At present, he is in leave, but I have contacted him, my lord. He's saying within few days, he'll place it before the alert. He has recently joined, my lord, within 2-3 days, most probably within a week, he
We'll fix it after 10 days.
Yes, ma'am.
Kindly come back with something. updated.
2 weeks, let it be after 2
2
weeks.
weeks. Okay. But Mr. So-and-so counsel looking for the petitioner also. A government advocate, who on request made by this court has obtained instructions from the judicial department regarding the present status of the
File numbers.
views which were sought.
File number.
Views which were sought by file number 663644. Stop. It is submitted that the concerned person dealing with the file was on leave and has recently joined back in office and assures that appropriate actions will be taken within a period of 10 days. Full stop. Accordingly, list this matter after 2 weeks on a date to be fixed by the registry, by which date is the government advocate may apprise the court, shall apprise the court the updated status of the file process undertaken. Yes, ma'am. Have it after 2 weeks.
Highly obliged.
That is very infractuously going, no? None appears for the petitioner on call. A submission has been made by the counsel for the appearing for the PNRD department that this matter has become infractuous. On earlier occasions also, there were instances of non-appearance on behalf of the petitioner, and at times adjournment had been sought for. Today also none appears in the matter. The petition is closed, closed for, dismissed for non-prosecution. Yes. Rules in বেলেগ fix নাই খালি একটু এইটো কৰি দিয়ক এইটো দি দিয়ে আমি কৰি দিব পাৰি Yes, sir, anything?
My lord. So far as the question, what right do I have? To that, my lord, my possession itself is recognized, my lord, as a right. If your lordship come to section 110 of Evidence Act and 113 of this BNSS, my lord, that recognizes, actually that is on the procedural part, but that recognizes that possession itself is a title. No doubt that can be defeated by better possession. But that is a possession, my lord. And if your lordship has the BNSS or Evidence Act, my lord, BSA नहीं है.
Evidence Act which will be provision?
My lord, which one?
Evidence.
Evidence Act, 110.
Okay. And?
My lord, at section 6 of Specific Relief Act. Section 6 of Specific Relief Act.
Okay. Just a minute, we'll just take one small. Yes.
My lord, that also recognizes and protects the possession of a person in spite of the fact that he doesn't have any title.
This is what?
That first, my lord, may take up the AR 1990, my lord. That paragraph 2. And I have highlighted the relevant parts. May I read, my lord? On the basis of this evidence, the division bench came to a conclusion that the date of plaintiff entry in the land is shrouded by mystery, meaning thereby that the actual date of entry is not known, but could be any time before so and so. The division bench therefore held that the possession of the plaintiff was long peaceful and lawful, and it lends presumption of title.
Yes.
It is therefore obvious from these facts that the plaintiff were in possession of the land for more than 60 years prior to the institution of the proceedings under section so and so. So we therefore do not see any infirmity, the impugn order of the High Court. Now, my lord, the possession gives a presumption that I have a right.
Presumption of title in your favor.
Right.
Yes.
And 1989, my lord. Paragraph 8, my lord.
person is in settled possession of property, even that's forced to lock. Okay. If any authority be needed for the proposition, we would report. Yes, read.
My lord, the possession is not only recognized but also protected. my lord.
Protected. And this Bharatiya Nyaya Sanhita, you are referring to what?
My lord, BSA, Saksha Adhiniyam.
Okay. Here it
Now
is.
that is now it is now in section 113. my lord. So, my lord, another aspect, my lord. The respondent number 2 has said that I have allowed to remain him in possession. Okay, this is there. But in his application itself, he said that dispute started from the year 2012. Meaning thereby, prima facie, my lord, that. But
now no prima facie, now final facie.
No. Regarding my right. Regarding my right. Now, from the year 2012, from the petition itself, the dispute arose from the year 2012, meaning thereby my earlier permissive possession has turned into a hostile one. Now it is 2025, my lord. So adverse possession 12 years. I need to submit on that fact, my lord.
Turns to hostile.
My lord. So what is my right? That I am trying to show. Otherwise, in what I have raised, what position I have raised, for that what I do have right, that is in my humble submission, perhaps not required. But whatever, because of that I have.
It was
submitted
because
this.
of the judgment which you had placed here
My lord.
that this issue arose.
My lord.
The judgment that was placed by you, Vanita judgment.
Vanita judgment, yes,
and
that issue has arose.
And understanding that this court had of that particular judgment that this issue has come up, whether you have a right to be there in the property at all or not.
My lord, that is why. Now, my lord, if your lordship permits to the Vanita's judgment, my lord, I have earlier referred the paragraph 17, but 16 is also most important because in the paragraph 16, Vanita's judgment. Morning.
Vanita para 16.
16, my lord. If your lordship asks me, allows me, then I'll read the, my lord, paragraph from subpara 3, my lord.
If any senior citizen.
My lord.
The deeming consequence, which paragraph?
That 16, paragraph 16, that next page, my lord, the subpara 3, that onwards, my lord.
Please.
Yes. If any senior citizen is incapable of enforcing the right under section 1 and 2, action may be taken on his behalf by the organization referred to explanation to subsection 1 of section 5. Subsection 1 of section 23 covers a situation where a property has been transferred after the enactment of the legislation by a senior citizen by gift or otherwise, subject to the condition that the transferee must provide the basic amenities and physical needs to the transferor. In other words, subsection 1 deals with a situation where the transferor of the property is accompanied by a specific condition to provide for the maintenance and needs of a senior citizen. In such event, if the transferee fails to provide the maintenance and physical needs, the transfer of the property is deemed to have been vitiated by fraud, coercion, and under undue influence. Subsection 1, in other words, creates a deeming fiction of law where the transfer of property is subject to a condition, and the condition of providing for maintenance and the basic needs of a senior citizen is not fulfilled by the person upon whom obligation is imposed. Then the option of the transferor, the transfer can be declared as void by the tribunal. This is regarding subsection 1, my lord. On the other hand, subsection 2 of section 23 envisages a situation where a senior citizen has right to receive maintenance out of an estate. Where such a right exists, the right of maintenance can be enforced where the estate or a portion of it is transferred against a transferor who has notice of the right. Or if the transfer is gratuitous, the right, however, cannot be enforced against a transferee for consideration and without notice of right. Now, subsection 1 of section 23 envisages a situation where the transfer of property is by a senior citizen. This is evident from the language of subsection 1, namely, where any senior citizen who, after the commencement of this act, has transferred the way of gift or otherwise the property. On the other hand, subsection 2 of section 23 does not confine itself to transfer by a senior citizen. Unlike subsection 1, subsection 2 uses expression such estate or part thereof is transferred, where the senior citizen has a right to receive maintenance out of the estate or any part of it is transferred. Subsection 2 permits the enforcement of right to receive maintenance out of the estate against a transferee which
Mr. Sahu,
notice, my lord,
the thrust of your argument overall is
my lord,
there was no transfer of property to you.
my lord,
Even if there is a transfer of property to you,
my lord,
it was not on the condition of being maintained,
my lord,
and therefore the tribunal erred when it said that the respondent parent would have the right to oust you from the property. The invocation of the powers or the provisions of 23(1) was wholly uncalled for, and therefore the tribunal made an error.
no, my lord, because subsection 2 provides a power, but
Only in cases where there is a transfer on the ground that there should be that you would maintain it.
but now he has a right to maintain himself out of the property owned by him. This is important line, my lord.
That he must have a right to
Maintain himself out of the property owned by him.
So there are circumstances. Can you give me a circumstance where a man or a person is the owner of a property without a right
My lord,
to maintain himself out of the earnings of that property?
my lord,
Give me a situation.
in that case, my lord, the concept right of maintenance himself and right of receive proceeds or profit out of the property is a different perspective.
Yes.
Two
Let
different
us not go into
concepts.
academic things. Any further thing you want to show?
My lord, these are the, and one more fact, when the married daughters, my lord, in this case, the married daughters, they are disturbing. Actually,
They are?
Yes,
They are disturbing
they are brainwashing the
old men
old man
against the son.
against the son. And when a married daughter interferes in the paternal affairs of the family, my lord, this epic of
These ladies should not be allowed to be there.
my lord,
Married daughters should not be allowed to.
no, my lord,
Moral policing.
because now under this socio-economic structure, my lord, it has become a universal fact, my lord.
That the daughters
Whenever they come,
beyond sitting in this court, we would like to tell you that the daughters are the best blessings one can have in life. Sons move out, daughters come back. So I would differ on that.
my lord. And I have prepared one, my lord,
Written argument.
submission, my lord. That I'm,
That will help us.
my lord, half an hour is required. That is ready, and
Take your time.
Yeah.
Take your time. We are not dictating the judgment now.
My lord,
Take your time. By evening, you give it to us.
my lord,
We'll have a decision this way or that way.
my lord.
But never again in this court would you say that daughters
My
interfere.
lord, that part.
Daughters.
I
will not take.
My lord,
Yes, madam. Anything in reply?
No, lordship, that civil part, he is saying that ownership gives a title, lordship, that is in regard to civil dispute, lordship. Whether he has a right as a son.
No, what do you have to say to his assertion that a man may have a property and yet may not have a right to maintain himself out of the proceeds of that property? It is my property and I will not have a right to maintain myself.
Lordship, it is my property. I can use it for my enjoyment, for my maintenance. It is my property. Question is
Okay.
that it is my property.
Uh,
Already the three decisions I have already cited, Lordship, that says, Lordship, transfer is not necessary for utilizing section 23. And when there is a disturbance by the son, then only the father goes to an extent that he declared an affidavit saying that you are no more my legal heir.
Rajyaputra.
Yes, Lordship. That is in the section 7 petition also he has mentioned.
We all know the value of say.
But Lordship, he declared that in page 20, your Lordship will find, accordingly, the petitioner sworn a declaration on 24/2/2023 stating that the OP shall have no right to inherit his property forever. The petitioner has already abandoned the OP and disowned the OP forever by depriving the OP from the right of inheritance, as well as hereby terminate all relations with the OP forever, which the petitioner declared voluntarily without any coercion or threat. The petitioner also sent notice to the OP with a photostat copy of the said declaration with a direct to vacate the premise of the petitioner along with all their belongings. The said notice was duly delivered to the OP on 2/3/2023. So since a long time, the father is, Lordship, trying to evict them.
Okay, heard Mr. Sahu, Learned Counsel preparing for the, start with like this. But Ms. R. Chaudhary, Learned Counsel appearing for the petition, appearing for the applicant in the IA civil number so and so. Also heard Mr. S. Sahu, Counsel appearing for the writ petitioner in WPC number so and so. And the opposite parties in the IA. In the earlier order,
No.
this court had recorded the consensus of the parties to take up the matter in its entirety, instead of taking up only the IA for disposal. Arguments were heard on earlier dates, and today the arguments have been concluded. Mr. Sahu has prayed for the liberty to file written arguments in the matter, which is permitted. R. Chaudhary also may present her stand in the form of an argument.
Lordship, written argument today may not be possible.
I said we'll have the liberty.
Lordship.
Arguments hearing concluded, judgment reserved.
Lordship has gone through that citation, the Justice Santi Sarup Dewan, Lordship.
No, you have to
Yes,
give me
sir.
the name of the case. What is the name of the case?
Justice Santi Sarup Dewan. The Chief Justice retired versus Union Territory of Chandigarh,
Was it supplied? Yes, yes.
Punjab and Haryana. Lordship.
Mm.
The Lordship will find there the society has gone to that extent, Lordship, the
The Chief Justice of a court retired.
Lordship.
Good.
very pathetic, Lordship, and it is not necessary that every time they should help by monetary assistance to father, Lordship. There are some other aspects also which is necessary for a father, Lordship, to survive in this world.
Maintenance is not only by money.
Yes, Lordship.
Maintenance is also by
Care, protection, and
peace
love,
and
affection,
harmony.
everything, Lordship. Obliged, Lordship.
Refuse, Lordship. Lordship, we have filed an additional affidavit today.
Hmm.
The same may come on record, Your Lordship.
It's not come on.
This is not common record.
You received a copy?
Lordship, we received a copy, but Lordship, we have some urgency, Lordship. Can the matter be fixed on Tuesday, my lord?
I'll take it.
So the some land was identified and you
Yes.
required to have a instruction on that.
Yes. We have
What is
put
it?
it on the affidavit, Your Lordship. The land is not habitable. We have put everything in our affidavit, Your Lordship.
Okay, the learned counsel for the petitioner submitted that they have filed an additional affidavit. Your affidavit has been filed. This But that affidavit is also not.
That affidavit is second filing. There is no
That an additional, that an affidavit had been filed in WPC number 2288 of 2024. By the Revenue Department, bringing on record the proposal for giving alternate, for identifying an alternate plot of land. Full stop. The Learned Counsel for the petitioner has submitted that they have filed an additional affidavit. Ekon devotion by second copy. Ekon of land, no second. That an additional, the Learned Counsel for the petitioner has submitted that an additional affidavit has been filed on behalf of the petitioner today. However, the same is not found on record. The
They have filed it today.
inhabitable.
Affidavit, yes.
You have given an inhabitable alternate piece of land.
Yes, alternative piece of land. To that extent. they
But
have
then it
filed
is
a-
human to make it habitable, is it not?
But I will satisfy your lordship.
The paddy field, Your
you
Lordship.
have
We
to
have
make
also
it
annexed
habitable.
pictures.
No, my lord, now the time has come that the enclosures have started dictating. I will satisfy. I will satisfy my lord. My lord, I can pray, my lord, let this matter be fixed on next
After
week.
You do not seem to be satisfied with the stand of the petitioner. How will you satisfy?
I will.
Anyway, since the affidavit in reply, additional affidavit is not on record, Command list this matter again in the next week.
After next week, my lord, any date, my lord, because we are in extreme
In
urgency,
the,
my
ne-
lord.
on, in the next week,
In fact, on Tuesday, my lord.
on
Tuesday
One,
or
1 week, Your Lordship.
Tuesday,
Wednesday also. No difficulty.
yes,
Right.
they have some urgency. You are sitting on the land. It has to
Well,
be
let
argued
it
and
be- let it be on
Tuesday, fine,
Wednesday.
Lord.
Tuesday.
Wednesday, my lord.
When-
Let it be on Wednesday.
Ladies, on
Wednesday.
Wednesday,
My lord,
Wednesday,
Wednesday.
12,
12,
12,
11.
2025,
Interim-
along with the affidavit filed by the petitioner. Full stop. Mr. Arbor Pujari, Learned Counsel appearing for the Revenue Department has expressed urgency in the matter.
Interim may be continued, Your Lordship.
The interim order shall continue in the next date of listing.
Going for a response number 9.
Exponent number 9 is Burwa.
E. Barua.
I'm so obliged.
My pleasure.
Yes, sir.
My lord, in this case, the petitioner number 2 husband had let out a RCC building at Bonda to the State Bank of India on monthly rent. Lord. Thereafter, the father of the petitioner number 3, Suman Talukdar, he expired. Then the bank has started to pay the rent to the present petitioner. Lord. All of a sudden, a lady, Mamoni Devi, she filed an objection before the bank that she is the second wife of the deceased Suman Talukdar. And the bank hold up my account. I am not in a position to draw the amount. Petitioner number 2 is a widow, lordship. Petitioner number 3 is a unemployed youth. There is no any source of income, lordship. And the bank, your honor, lordship, in filing the affidavit of opposition stated that if the succession certificate is obtained, then the petitioner will be entitled to draw the amount. That letter is in the additional affidavit filed by the bank, lordship. Your lordship will please to peruse the
So what is the difficulty in getting a succession certificate?
No, we have already produced.
I have provided already succession certificate we obtained.
Has been given.
Yes.
Yes. I have annexed that. Lordship, please to take up the affidavit in opposition filed by the bank, lordship. The additional affidavit filed by the petitioner, lordship.
First, the affidavit by the bank.
No.
No,
this
my,
was when
my
I said-
additional affidavit.
We can't take up both together, sir. We can take up only one at a time.
Additional.
No, additional affidavit.
Additional affidavit.
Additional filed on 3/6/25.
P625.
Your Lordship will be pleased to come page number 203.
203, yes.
This is the letter dated 11th of March 2020 issued to Nuripma Talukdar. She was the original petitioner number 1. She expired. Then Barnali Das, she is the widow. And Darshan Das, he is the petitioner number 3. And the petitioner number 4 is Mamoni Devi.
Number 4, respondent.
The respondent number 3 is Srimati Mamoni Devi here. Here is the name has been shown. Then your Lordship will be pleased to come to next page.
Page 20.
205, Lordship. Here it is. In the middle portion, Lordship, however, the area rent.
Who has given this legal notice?
This bank has been given notice to the parties, Lordship.
Legal notice to the parties.
Petitioner and
No, petitioner has given the petitioner's advocate, Lordship, given notice to the
No, I think there is some mistake because this is addressed to the petitioners.
yes, it's bank.
address to the bank has given to the petitioner.
In reply to their notice.
Yes, Lordship.
And, okay.
Now your Lordship may be come to the next page. Page 205, Lordship. In the middle portion, Lordship, however, the area rent. Lordship got it?
Where is that lease agreement?
Lease agreement, Lordship.
Show us the lease agreement.
Yes. Lease agreement.
Agreement नहीं है. Lease agreement bank to display.
नहीं. Lease agreement, Lordship, earlier lease had expired, then the bank requested the petitioner, Lordship, for the renewal of the lease, Lordship. That your Lordship will find it annexed 13, page 89. Page 89 of the writ petition.
We do not have the first lease with us.
First lease, we have not annexed, Lord. It is there. File में है, देखो, file में हमने, देखो.
Yes, what happened after 38/2023? Was it extended?
No, bank has written letter, Lordship, to the petitioner for the, I am having the copy of the lease.
First lease.
First. So, Lordship, this is the initial lease deed.
बैंक अपने additional affidavit में file भी किया है.
I have also, the bank has also filed
In their affidavit.
in their affidavit of opposition, the original lease deed. Next page.
106.
Page 106 of the affidavit of opposition filed by the bank.
And thereafter what happened? Now, renewed lease, then they have said that we are holding up your account.
Because the respondent number 3, she filed an application before the bank. That she is the second one.
Then you have a succession certificate in your favor?
Yes.
With regard to that? With regard to?
Succession certificate of late Suman Talukdar.
Did it include this bank account? The money is being deposited in the account of Mr. Suman Talukdar.
Yes.
Your own
Yes.
account.
Yes.
Whose account?
No. Money had earlier it was deposited in the name of the original landlord, Suman
Yes.
Talukdar.
On his death, he took out all the money.
The bank started to deposit the rent in the bank account of the petitioner number 3, who is the son of the deceased.
Darshan, yes.
Yes, Lordship. All of a sudden, the account was held up.
And then why are the other petitioners before this court? If the account of the petition number 3 is kept on hold, why are the other petitioners before this court?
Lordship, because Lordship, after death of Suman Talukdar, bank started to pay the rent to the petitioner number 3, Darshan Talukdar.
True. Then why petitioner number 1 and 2 joined in?
She is the mother, Lordship, because after death of she is the mother of Suman Talukdar. She also expired in March, Lordship. That's and the third petitioner is the son, Lordship. They do. they do not have any other source of income, Lordship, and the mother of Sumant Talukdar expired, Lordship, because proper treatment could not be given. There was no money to treat her.
Saving on this rent, depending on this rent. Like they would-
Ah. Only source of income is the bank rent. And the Lordship, in the additional affidavit,
Where is your annexure 9, sir?
Annexure 9 of the
Yes.
writ petition. Lordship, annexure 9 of the writ petition. Annexure 9.
85.
Eh?
Page 85.
Hmm?
85.
क्या बोल रही हो?
Page 85. Annexure
Page 85, Lord.
Page 85, yes.
Page 85, this is the letter dated 2/6/20, addressed to Darshan Talukdar, petitioner number 3. With reference to your application dated, I have to mention that the rent payable for the branch as well as generator had been put on hold since the demise of Sri Sumant Talukdar, as some dispute pertaining to the property has arisen. The details of the various rent payable as appended below. So details of the rent has been given, Lordship.
यही इसी लेटर से rent.
And where do we find that your entire account has been kept on hold?
This letter.
This is the letter, Lordship. This has
This letter says that
has been put on hold.
rent payable has been put on hold. They have not deposited the rent into your account. The rent has been put on hold.
No, rent
The
has been
account
put
is
up
not-
on, no, Lordship, it is admitted fact that up to 2020, the bank has deposited the rent in the bank account of the petitioner number 3, Darshan Talukdar. Thereafter, Lordship, they are not even depositing in the bank. Until now, the amount has gone to almost 50 lakhs, Lordship.
Mr. Roy, what we understand is you have said that the bank account has been put on hold. You are not being allowed to operate the account.
I am not allowing to draw the amount.
Which amount?
The rent which has been deposited
Not
in
the rent amount. Are you allowed to operate the bank account otherwise?
Otherwise, no, Lordship, if I am not allowed to draw, so almost it will be deemed that the account.
That account is not only for the rent. That account will also have other purposes.
That account is only for deposit of bank.
So you don't have any other money in that bank except that
No,
rent account, that rent amount.
no. That account is only for deposit of bank.
So now you want the rent to be deposited and you should be allowed to withdraw it.
Lord.
You have,
Because Lordship, be pleased to peruse the additional affidavit filed by me, by which the bank has admitted that you submit the succession certificate, we will release the rent.
Where
You
is
can
that?
withdraw. The-
Page 206.
206, Lord. Of the additional affidavit.
From 203, sorry, 203.
It starts from.
Relevant portion is at 205.
Lordship, this is the letter 11th of March 20 by the bank, Lordship, advocate to the all the stakeholders, Lordship. And page, your Lordship, may please to come to page 205. In the middle of the letter, Lordship, however, the area rent will be disbursed.
yes, where is the succession certificate you are saying that
Succession
you have?
certificate, yes, Lordship.
Next letter we have submitted by notice letter.
Next letter is
207.
207.
Page.
Lordship.
This is, by this letter we submitted our certificate.
By this letter, Lordship, we submitted the succession certificate. Main date petition में है तो
Annexure 7.
And Lordship, we have submitted page 208, Lordship, Annexure Roman 8, we have submitted the succession certificate. And in the writ petition also, I have annexed that succession certificate, Lordship, that is
Annexure 7.
Annexure 7, Lord. Annexure 7 of the writ petition, page 72 is the succession certificate.
Hmm.
And Lordship, the bank cannot be allowed to hold up the account because Lordship, that is the fundamental right of the customer, Lordship. There are two side judgments of the Calcutta High Court and Delhi High Court on this point.
In a writ petition.
Yes.
Yes.
Rajasthan High Court.
One is of the Rajasthan High Court, Lordship, and the other is of Delhi, no?
So these are with regard to the freezing of accounts.
Yes.
Yes.
We could have the.
Hold up means the root court had the jurisdiction and holding up the account amount to.
Definitely, if your account is held up by an authority, by a public authority, it will lie. Yes, sir. For the bank.
Already in this case, the bank has put on hold the account only because, my lord,
Very
there are
good.
several claimants.
Mother and son having a fight as to who will take the rent, and therefore the tenant decides not to pay.
Not only mother, my
Very
lord,
good.
there is another wife,
Hmm.
second wife.
Hundreds of them. You have a lease with someone. How do you hold back the rent?
My lord, because the
You don't know whom
ownership,
to pay.
ownership is not decided, my lord. Who is the owner? My lord, she
Is
filed a
the
suit.
state from when is the state bank becoming a civil court?
My lord,
You are a tenant.
I am a tenant. Now,
Whom to pay?
now, my lord, second wife also coming forward and saying, give us the rent to give the rent to us.
Now what do you propose to do?
My lord, they have filed a civil suit
Huh.
for declaration of right, title, interest, and all.
Hmm.
Civil court has passed.
You
and
asked for a
state of court.
succession certificate.
My
Your
lord,
bank asked for a
and that
succession
is what, my
certificate.
lord, the second affidavit which they have filed, my lord.
Hmm.
I didn't have the copy. We have not been served. My lord.
Sir,
The
My lord,
annexure is there in the writ petition.
my lord, I will have to respond on that, my lord,
You
because
have filed your affidavit.
I will file, my lord.
No, no,
Because-
you have filed.
Yes.
No,
Still they
No,
have
no.
not filed.
additional affidavit, my lord, I have not.
No, original writ petition have you?
I have filed, my lord,
Yes,
but
that
in
contains the
additional,
succession certificate. What do you say on that?
in additional affidavit, they have, my lord, placed the succession certificate.
Not
The
in
bank
writ petition.
itself has
Not in the
annexed
writ
the
petition. Not in the writ petition.
bank has
That's why-
admitted in
that's
the
why-
affidavit
that's why, my
position.
lord, we need a copy of the additional additional affidavit filed by them, and we'll, my lord, like to respond on that.
Notice me who.
Lordship, this matter is pending since 2000. It was filed on 30th of March 24.
My lord, your
And the
lordship,
family
can you
is
see,
starving.
Please come to page 72 of the writ petition.
Page 72 of the writ petition.
Yes.
Successions.
Yes, my lord. But thereafter, my lord, the title suit was filed by them. And the civil court has passed the status quo order, my lord,
Regarding what?
In regards to.
regarding ownership
Of
of the property.
any stay on the rent?
Leased out property, my lord.
Any stay on the rent?
Status quo order in respect of the suit property.
No. There is no such order.
Yes,
Court
my
has passed the order restraining the defendant, that is the here the respondent number 3, from alienating the property in any manner. My lord. And
My
Lordship.
lord, your lordship kindly, my lord, see the affidavit that we have filed, my lord.
Okay, pretty good. Lordship, as per the family code, civil suit in the civil court is barred under section 7. Civil court does not have the jurisdiction to
Correct, my lord.
decide
Why
the
they have
status.
filed the suit?
Let me sum.
Why
Let me
they
submit.
have filed the suit
Civil court
before
is
the
not
civil
have
court?
no jurisdiction to decide the relationship between wife and husband, Lordship. regarding property or marital status. 7th section of civil, 7th of the family code is very clear, Lordship. There is a absolute bar. In spite of that, Lordship, there is, I would like to place the what order was passed by the
Now, my lord, unless the civil
Seven.
side, my lord, the
page 94 of my
ownership of the-
petition.
ownership of the property, my lord. Suppose today, my lord, we pay the entire amount. What they say, my lord, to Darshan.
We absolve you of that responsibility.
My lord,
If it is paid to their account, whatever will be recoverable will be recoverable from
it
them.
will be very difficult for my lord, for recovery of the amount, my lord, because
From
my lord,
whom? Why are you
from
worried?
Darshan, from
Why are you
Darshan,
worried? Why are you worried?
from Darshan, my lord, because
You have
entire
an
amount,
agreement with whom?
I have an agreement with my lord, the earlier owner who expired in the meantime. The
Thereafter,
father of Darshan.
thereafter,
Thereafter,
there was
no
a
agreement.
renewal, some proposal
There,
from your
but
end.
thereafter dispute started, my lord.
Thereafter, there was some proposal from your end to renew it.
Yes, I have annexed that.
Mr. Roy, we are trying to talk with him. You can take your seat for some time. So there was a proposal from your end.
Proposal. Then, my lord,
Just a minute, just a minute.
Correct.
They said we want to enter into an agreement with you.
Yes.
A dispute started.
After expiry of the owner.
Okay. Thereafter, you are sitting on that property, not paying rent.
No, my lord.
On what
There-
authority are you there?
My lord, thereafter, when
Do you have a lease?
now, my lord, there is no lease because the dispute started after, my lord, expiry of the owner.
In a dispute between the
The
owner
second
and
wife, my lord, the second wife has come forward, bank and
so
filed.
we are trying to
my
we are
lord,
trying to come to a conclusion. We are
filed
trying to
it-
come to a conclusion.
my lord.
Disputes can be raised everywhere and everywhere. Let us try and come to a conclusion. You are sitting on a property. You had a lease with some person. You were paying the rent on a particular account on the basis of what? Because that person, according to you, is the legal heir or next of kin or has a succession certificate or whatever, you were paying his son.
Yes.
One person comes and tells you that, look, I have a dispute with this property. This property is under status quo. There is an order of status quo. You understand the status quo to mean you will continue to use the property. You will continue not to pay anybody.
No. We are ready to pay, my lord.
To whom?
We are depositing every
So-
month, my lord, in
so
the
now-
bank account, my lord, of Darshan Talukdar.
Now that you are in the property,
My lord.
under what authority?
My lord, I am as a tenant, my
Of
lord.
whom?
Tenant of, that is not
Of
decided.
yes, yes.
That is not,
Now,
that is.
now
that
tell
is
us,
the dispute, my lord.
you are a tenant under whom?
That is the dispute, my lord, under whom? He is claiming.
So
my lord,
when you
he's-
do not know under whom you are a tenant
I am a tenant.
and
tenant.
you are a split.
My lord, unless, my lord, now ownership will be decided by, not by this on
Yes.
spot.
Do you have any other points to make on law? What is your jurisdiction to hold up the rent when you are under an agreement or you are under a property?
Because
When
tomorrow,
the
my lord,
dispute does not
tomorrow,
go-
my lord, if civil court says, my lord, no, she is not the owner, owner is somebody
the
else.
money will be recoverable from him who was not the owner, not from you.
No.
How can it be recoverable from
After
you?
all, this is a public money, my lord, it is very
No,
difficult
it is
to
the money
recover.
being used by the bank.
My lord, correct. My lord, unless and until, my lord, it is decided by the civil court, my lord, with regard to the ownership. My lord, bank has no hesitation to pay Darshan.
Yes, Mr.
But
Roy.
because my lord, lordship
Mr. Roy,
kindly
just
see-
tell us one thing. Just tell us one thing. You are asking for rent.
No.
Is this writ for the forum?
Yes.
Yes, Lordship, the account has been held up. I am aggrieved by the letter issued by the bank holding up my
Are
operation
you
of,
holding up the account?
yes,
Have you sealed the account? or what do you
Not,
call
my
it?
lord.
No, I have,
Not-
I placed
My
that
lord,
letter
My
before.
lord, the rent has been put
Stop.
on hold.
Rent, recovery of rent.
Other transactions, my lord, it's there.
That account already
Recovery of
have.
rent, sorry.
The rent because
Yes.
ownership is in dispute.
Lordship, may I please
Mr.
to
Roy, we will fix this in the in the last week of November. You have suffered so long, suffer somewhat. Last week of November. Kindly have your instruction because this letter, as I have seen it now.
Lordship, it is remitted position. Your Lordship, may please to come to page 105 of the affidavit of
Yes, yes.
position of the bank.
105.
104, Lordship.
104.
Lordship, the first line, situation, the deponent had no option, that is bank, but to put on hold the account of the petitioner number 3.
Not-
There is no
not-
dispute, Lordship,
not
and my
account.
learned friend does not know, Lordship, the expiry of the agreement, the tenants become a statutory tenant under the Rent Control Act.
No, my lord, that will be decided by the civil court. That is what, my lord.
What
we are
civil
well
court has no
understanding.
jurisdiction to decide a matter
My lord, we have been
relating
made
to the wife
party.
and husband?
We
Lord.
have been made party.
Only
in the
family
civil
court is the
We have
competent
filed our
authority.
written statement. We have taken on our
Who
stand
has
in
filed the civil court?
My lord,
Who has filed the civil suit?
they have filed the civil.
You have filed the civil.
Yes.
I have filed this, he occupied my property for civilly.
and in the civil suit, the bank is a party.
Yes.
No, bank is not a party,
But-
and civil court did not grant any status quo order, Lordship,
But-
page 94, na?
None
Page
of
94.
My lord,
Just a minute,
thereafter,
just.
my lord,
Beyond
None
the
of
report,
you-
my learned friend is submitting, Lordship.
None of you are prepared. None of you are giving me the facts that I want to have. And therefore, I'm fixing this matter on the last week of November. Kindly have your instructions if this is a case for rent. Whether the writ court will sit here to give you the rent.
No, it could-
Kindly
it is-
have your instructions whether just because there is a dispute on the ownership, you can hold
Lordship,
back
the
the whole rent.
Judgment, I have two judgment, I have.
Yes, these are
In the
regarding
judgment, the account said freeze.
Mr. Roy. On this judgment, we can direct them to unfreeze your account. We can direct them to allow you to do all transactions that you want in your account. That is not giving you the rent.
No, they have already deposited.
No, they had deposited the rent in the bank account of the petitioner number 3. Lordship, I have clearly stated in my petition.
Their affidavit
In the statement of
letter says-
account also I have given for annex Lordship.
Your letter is saying
Read
something
petition.
else.
Lordship, may please to peruse the
Yes,
petition.
please come to page 85 first. Let us be page 85.
85 of read.
Oh, yes.
Yes, you know.
Yes, this is the page 85 letter by the bank Lordship.
Now it says, I have to mention that the rent payable for the branch as well as generator has been put on hold since
the
the
demise of
demise of Suman Talukdar.
Hmm.
Now please come 2 lines below that.
Hmm.
Branch rent payable as on 2/6/2020. That is the date of the order
Hmm.
of this letter.
Hmm.
Rent has been put on hold since October 2019. That is 9 months rent. Total payable is 54,000. Total payable rent is 4,92,000. Am I reading it correctly? So
Yes.
they have put this on hold. They have not paid you the rent.
No, but.
It is not
deposit-
deposited.
Subsequently,
in your
they had
account.
deposited. I have the their.
Where is it?
Yes,
Page, next.
next page Lordship.
Statement of.
Next page, here statement of account. Entire amount has been credited to the bank account of the petitioner number 2, 3. That is their document, Lordship. My learned friend is submitting beyond the
No,
pleadings.
that is there, my lord,
Yeah.
but since the ownership is
Your Lordship
disputed,
will
my
see
lord,
the date of deposit, Lordship, 26th of September.
now, my
You are
lord,
simply holding up the bank transaction,
Yes.
the account transaction.
not account transaction, my lord, only the rent. Rest, they can, my lord,
What gives you
transaction
that
is there,
authority?
my lord.
What gives you that authority without an order of the court? There is no court order restraining the operation of the bank account.
No.
There is no court order restraining the
My
payment
lord,
of the
my
bank.
lord, there is a standing order, my lord, there is a standing order.
Please.
Oh, my lord,
Show us.
paragraph number 14, my lord, lordship, can you
Of-
see
of-
paragraph number 14 of our affidavit?
Affidavit, yes. Let's do this today, yes. Yes.
B.
Under what? You have
B-
given
B-
this 4, 5, 14 A, B, C, D. Under what?
B, my lord.
Under what?
B.
What are these provisions
Bank
relating
must
to?
comply with the court's order, government investigation,
Sir,
law
is
enforcement,
is
and
there a
subjected
legal,
to legal
is there a legal document where these things are written? Where is that?
My lord, that is why I am saying, my lord, that now this second wife has filed a suit for eviction against us. My lord, I need to file all these, place all this, my lord, on record by filing an additional affidavit in reply to their additional affidavit.
In the meantime,
That is why, my lord, I say, my lord,
petitioner will die due to starvation.
some time, my lord, at least 1 week may kindly be allowed, my lord. I may be allowed to place on record the documents, my lord.
Additional
That is the
with
now
couple-
civil suit filed by the second wife. Second wife has filed a civil suit for eviction against us. She is claiming the owner of the property and arrayed as a tenant and seeking for, my lord, eviction from the same suit premises.
Who?
This Mamuni Devi, my lord, who is the second.
She received the notices.
Claiming to be the wife of the, my lord, the deceased. Second wife of the
Notices were issued to Mamuni Devi, the respondent number 3. She did not file any affidavit of opposition. She did not appear. No counsel has been engaged. That is the position, Lordship.
So, my lord, the second title suit that has been filed.
And
by
I
the
am ready to
second wife-
execute a bond, Lordship. If the, any degree is passed in favor of Mamuni Devi, respondent number 3, I will refund the money. What more?
Whatever there is in the.
Yes.
Whatever is there.
Because bank itself can deduct from our rent. So there will be no loss or injury to the bank, Lordship. Each month I am getting more than
How long, my
54
lord?
lakhs,
Say-
54,000.
Say if it is 50 lakhs, my lord, or something like
Sir,
1
the
crore.
lesser said on behalf of the bank who's sitting on a property without giving any rent and trying to justify the same, the lesser said.
My
the
lord,
better.
my lord, we are paying rent, my lord.
Yes.
We are ready to pay rent, my lord. But to whom, my lord? That is the question. That is the dispute, my lord.
He, my lord, the contradictory environment.
She is, my lord, claiming owner, and another lady, my lord, Mamuni Devi, she is also claiming that I am.
We will fix this in the month of November. If by November, please have your instructions when the bank can vacate the property and you find out whether this petition for rent is maintained.
Lordship,
But I-
till then, Lordship, the family is starving, Lordship. There is no income. Petitioner number 2 is the widow. 1 is the unemployed son,
maintain, my lord,
Lordship.
provided
Some,
I
at
shall
least
get them
25% amount
an
I may be
accommodation,
allowed
my
to
lord.
draw. Otherwise, they die. Petitioner number 1
Bank,
died.
my lord, it's not a, my lord, small premises that we can shift, my lord, at any point of time.
Hey,
It's
you are
my lord,
clear
my-
rank defaulter.
No, I am a rent defaulter. Let it be proved by
Sir,
the court of
everything
law,
you
my
are
lord.
saying is going for a civil suit,
Yes, my lord.
except the holding up of the account.
On decrease of the account.
No,
My lord,
this is-
let the civil court say I am a defaulter, my lord. Without, my lord, saying, without any ground for eviction, my lord, how can they say, my lord,
Bank is not a party in the civil suit.
not right? But Mamuni has filed a suit against us for
Silent
eviction.
suit, that suit is not maintained.
You are also party to that suit. You have filed your.
At least,
defense
Lordship,
statement.
at least 25% should be real. Otherwise, they don't have anything to maintain themselves, Lordship. Already.
My lord may fix a date, my lord, last part of November, my lord.
After spending so much of time.
My lord, it will be disposed of in entirety, my lord. Let us file an additional affidavit, my lord.
How much time?
Place it, my lord, 2 weeks.
Lordship, the additional affidavit was filed by me on 3rd of June 25. Copy was served, Lordship, without a Lordship, and my learned friend was under deep slumber and did not prefer to file the reply.
No, my lord, I did not receive a copy. That's why, my lord, I asked my
Without,
senior friend.
without serving
whether
copy,
my-
whether it can
my
be.
lord- Anyway, my lord, I'll file, I'll place. Let it
Record
on
will
after-
show.
My lord, last part of November.
Notices, dear lordship, in the bottom of my additional affidavit, acknowledging the receipt of the additional.
But then you had made a submission that the pleadings are complete.
Yes.
On 18th of August 2025.
My lord, thereafter,
No, June it was filed.
anyway, my lord,
The
I
additional
did not,
affidavit.
I did not respond on that, my lord. I would like to respond. to
Your
that.
period.
It is the petitioners who are facing the music lot.
नहीं हम लोग का प्रेयर ये नहीं है कि रेंट डिपॉजिट देता है हम लोग का प्रेयर सिविल सूट से रिलेटेड नहीं होता वैसे कि डिक्रीज करे तो ये कैसे सिविल सूट
Our prayer in the writ only to defreeze the account, nothing else.
not for deposition of rent.
So your only ground of keeping the account under freeze is that there is a dispute with regard to the property by some
And
third party.
litigation pending.
The litigation pending, therefore you have frozen his account. That is the only stand the bank has.
Because
I think then we can dispose this. Yes, stay.
no, my lord, that is not, my lord. My lord, I need to respond on the affidavit filed by them. That's
We will
what
not
I-
take into account the affidavit.
No, my
We will
lord.
discard the affidavit.
My lord, there are certain, my lord, subsequent events, my lord. They have filed the suit.
Subsequent to what?
Subsequent, my lord, filing this
Petitioner affidavit.
affidavit,
Hmm.
raise petition.
Yeah.
My lord, title suit filed by
Yeah.
his second wife.
Um,
That, my lord, that part, my lord, I need to, my lord.
yes, you will get that.
Yes.
Mr. B.K. Sen, Learned Counsel, appearing for the respondent, State Bank has submitted that there are certain recent
Your lordship was
developments.
brought on record in my, sorry lordship, in my.
Certain recent developments
After filing writ petition.
after filing of the writ petition, which could not be incorporated in the affidavit in opposition.
My lord.
And he would also like to reply to the affidavit, additional affidavit filed by the petitioner. In June 2025, good stuff. Mr. Espira, Learned Counsel for the petitioner, has submitted that the affidavit having been filed in the month of June
3rd of June.
2025, now a further extension to reply to the same is Anna has objected to such prayer of the Learned Counsel for the respondent on the ground that the affidavit in additional affidavit had been filed in the month of June, and now no further extension may therefore be granted. List this matter again in the last week of on the 26th of November 2023, 2025, by which date the respondents may file their additional may file their affidavit to bring on record any event subsequent to the filing of the writ petition which had already not been brought on record
It is on record.
before
Lord.
this court. Full stop. I gave the date list on 26th of November for further hearing. We'll have it on 26th of November. Bring on whatever records you want to.
It may remain as a part, Lord.
Further hearing.
Oh, as a part. Well, lordship 25, I may be allowed to draw only 50 lakhs amount is deposited. I may be allowed, how the family will survive, Lord? No, not a single paisa earning is there, like.
26th of November for further hearing. Further would mean that I have already heard to some extent and I will hear it further.
But sometime it happens, small, it is listed before other. Obliged.
Yes, Mr. Bhia.
My lord, that this is the matter that regarding Bukakhat bus stoppage and
Oh,
the
yes,
parking
yes.
issue. My lord, now my lordship wanted to know from the National Highway Authorities, my lord.
I have taken the verbal instruction, Lordship. As per my instruction, Lordship, that the road is under the position of the NHPWD state government.
It is not with you. So it is National Highways PWD.
Yes.
So it will be the Standing Council PWD.
PWD, next.
Standing Council PWD, who appears usually? Huh? I thought.
Nayak
Nayak is also there. Standing Council PWD का details. But any discussions between you people? Anything worth?
Lord,
Nothing. Scroll the details. Huh?
Nothing of that.
Okay, then
my
start.
lord,
with the PWD.
my lord, the only thing is that as per the permission letter, my lord, which had been issued by the additional deputy commissioner, my lord, may kindly have a look. My lord, I straight away like to draw my lordship's attention to page 44, my lord. Page 44 is the vernacular one, issued by the, my lord, অসম চৰকাৰ মহকুমা ধূপেত্ৰীৰ কাৰ্যালয় বোকাখাত উন্নয়ন শাখা সভাপতি সম্পাদক বোকাখাত সন্মিলিত যাত্ৰীবাহী বাছ মালিক সন্থাৰ আবেদন মৰ্মে চক্ৰ বিষয়া বোকাখাত ৰাজচক্ৰ সহকাৰী কাৰ্যবাহী অভিযন্তা গড়কাপ্তানী ৩৭ নং ৰাষ্ট্ৰীয় পথ বোকাখাত আৰু ভাৰপ্ৰাপ্ত আৰক্ষী বিষয়া প্ৰতিবেদন অনুসৰি দুখনকৈ বেচৰকাৰী যাত্ৰীবাহী বাছ ৰাজহুৱা বাছ আস্থানৰ পৰা ৩৭ নং ৰাষ্ট্ৰীয় পথৰ কাষত কেৱল যাত্ৰী উঠানমা কৰিবলৈ ৰাখিবলৈ নিম্নলিখিত চৰ্ত সাপেক্ষে অনুমতি প্ৰদান কৰা হ'ল মানিবলগীয়া চৰ্তসমূহ যি উদ্দেশ্যে এই অনুমতি প্ৰদান কৰা হ'ল কেৱল সেই উদ্দেশ্যতহে ব্যৱহাৰ কৰিব পাৰিব সকলো ধৰণৰ যান বাহন আইন মানি চলাৰ লগতে আইন শৃংখলা অটুট ৰাখিব ৰাষ্ট্ৰীয় পথত অহা যোৱা কৰা অন্যান্য বাহনসমূহৰ লগত পথচাৰীক অসুবিধা হ'ব নালাগিব সন্দেহজনক গৰাকীবিহীন চমিলত So, my lord, only basing on this permission, my lord, we were, my lord, parking two vehicles, my lord, under our association for the purpose of just picking up and dropping off the passengers, my lord. Now, taking advantage of this permission, my lord, this private respondent, my lord, has occupied the entire area and transformed this parking place into a bus stand.
This is issued to whom?
This is issued to us, the present petition. My lord.
Bus Malik Khanta. Then what happened?
Then, my lord, this permission, my lord, when we were operating the business in the same manner as specified in this permission order, my lord, then this private respondent appears.
Any business was permitted?
No, business means, my lord, the manner in which it had been directed to use the area, my lord, for parking place, my lord, for dropping and picking up passengers. Then, my lord, these private respondents, my lord, with the, my lord, some muscle power, my lord, has used up this area and transformed into this area into a bus stand, my lord. Now, therefore, there is a, my lord, we were nowhere, my lord, we are ousted.
Your prayer is that no one else other than you should be allowed to park vehicles in that particular area.
My lord, as if somebody had the permission, my lord, from the authority, they can. But, my lord, this such permission has only been, my lord, afforded to us, my lord, and given to us, my lord, this association, my lord.
This permission was granted to you by?
By the, my lord, অতিরিক্ত উপায়ুক্ত ভারপ্রাপ্ত মহকুমাধিপতি বোকাখাত, additional deputy commissioner, my lord, in the capacity of, lord. Now, they have not
Who
filed,
appears for the additional commissioner?
they have not filed any affidavit till date, my
What
lord.
is your stand in the matter?
My lord. My lord, allotted
Allotted what? Some more land to
some other.
some other person. Then is any of it on the national highway? That is a property?
My lord,
On the
admitted,
same property that they are permitted.
They are claiming as an exclusive possessor of this particular area.
They have permission for two buses.
Two buses, but now they have projected their case as they have.
And how, where is your permission?
Well, my permission I have enclosed with my in my affidavit in opposition, my lord.
Yes, page.
Lord, page 79 is my page 79, my lord. Is the society registration, my lord. 80 is the, my lord, 80 also society registration. 81 is the trade license, my lord. It's not that we
Mr.
are
Dotto,
running. Yes.
Specific question, where is your permission?
Yes. Regarding that, my lord, if you lordship, I once again read out, my lord. They are claiming that they have been allowed to park 2 buses.
You
in
have been
front of-
given a lease. Where is that lease?
No, I was not granted lease. This area was on lease by Bokakhan Municipal Board to LAC. And in that area, my lord, which starts from, my lord, Bokakhat IB to ASTC, my lord, including in front of this Uttam Hotel and Mona Lisa Hotel, my lord, where, my lord, they have claimed that, petitioners claim that they have chosen that place for to park 2 vehicles, entire area, my lord, where lease out, my lord. And anyone, my lord, whatever it may be, 2-wheeler, my lord, 4-wheeler, bus, traveler, whatever it may be, my lord, we have to pay the parking fee for picking or to the Bokakhan Municipal Board for picking up and dropping, my lord. My lord, we are paying the parking fee to the Bokakhan Municipal Board.
Who is paying for the municipal board?
Bokakhan
Not a party?
Bokakhan Municipal Board party.
They have filed an affidavit also, my lord. My
Who
lord, their
appears for
sta-
it?
Yes, yes. Their stand is clear in the affidavit.
Who appears?
My lord, affidavit filed by the, my lord, one Sri Ratneshwar Borua, my lord, chairman of the Bokakhat Municipal Board on 5/25/9/24, my lord.
Respondent number?
8. my lord.
Huh? First list. You have parking for two
Two private buses, my lord.
You are parking 2 vehicles there. There is no disturbance on that. No.
Now, my lord, that area is not for parking. They have, my lord, by using force, has converted this area into a bus stand,
You made a-
creating.
Did you make a complaint to the police?
My lord, we have made the complaint. My lord, it is in our petition also, my lord, we have annexed. My lord, kindly turn to page 39, my lord.
And they were removed.
Complaint.
Thereafter, they were removed. Then what happened?
Again,
My lord, they have initially removed, they have again come and occupied, my lord.
Is take down. Heard Mr. A.R. Bhiya, Learned Counsel for the petitioner. Also heard Mr.
53.
And you are appearing for Mr. Adrik? You are appearing. Who is 1, 2, and 3? Transport Department, Mr. M. Datta for. Mr. Nayak, what has happened in this particular matter? One party says that they have got a parking permission for 2 vehicles on the highway in Bokakhat. Allegation is that the municipal board has leased out another portion of the land where the clients of Mr. Dotto are using for parking and they are paying the parking. We just want a confirmation from the NHPWD because it is possibly now today we have been informed that this is under the Assam NHPWD. Any part of the national highway in that area has been encroached upon or is being used for this parking business or any other business either by the board, either by this party, to the detriment of the use of the highway. Highways cannot be used for parking or for stopping anything. There are sidelines, what do they call it, service lanes,
Service roads are
sort
there.
of things where they can go and if the highway has been leased out or if any part of that land which falls under the highways has been leased out by the municipal board, then what consequences to follow? Municipal board remains absent on every occasion. So since they have filed an affidavit and have not appeared now, today we'll order the personal appearance of the officials holding the municipal board.
Whether any portion of the
Yes.
has been
Either leased out or is being used by anybody for parking purposes. If so, under what authority? If not, is the highway authority taking the appropriate action to have that parking business being stopped?
Sure.
That is if the highway is not under an issue, then this fight we can try and settle down. If the highway is the issue, the first thing we need to do is clear the highway of obstructions. Highways have their own importance. That is why we requested you. So we are not recording anything at the order. The next day that the matter comes, we'll have your name reflected. Yes. Yes, percent. The issue in this petition is with regard to the parking of vehicles in and around the area near the National Highway at
Bokaka Town, Miller.
While the writ petitioners assert that they have permission for parking 2 vehicles at a particular location, the private respondents assert that they are also using
The area for
some of the area for alighting and for the passengers to pick up and drop passengers by paying parking fees to the municipal board, concerned municipal board. Full stop. It is seen from the records that although the municipal board has filed an affidavit in opposition, however, there is no representation on their behalf, no representation recorded on their behalf for the last several occasions. Since the matter cannot be adjudicated in the absence of the stand of the respondent number 8, that is the what municipal?
Bokaka Municipal.
Bokaka Municipal Board lists this matter again in the first week of December 2025. No, we'll have to give a date on 3rd of December 2025, on which date the respondent number 8, that is the chairman, Bokakhat Municipal Board, Bokakhat District, Golaghat, Assam, shall ensure representation on behalf of the municipal board, in case there is no representation, the chairman of the board may be required to be personally present on the next date. Appropriate orders may be passed to secure the presence of the said respondent on the subsequent date. List again on 3rd of December. If they are using the national highway clear, then we will see what. 3rd of December.
My lord, oblige, Mr.
Lordship, in response to the affidavit in opposition filed by the respondents, we also file our rejoined affidavit. So my humble submission is that let the matter may be fixed for the length of the heart of the.
Item 30, my lord, I appear for the respondent, Bridge and Roof. So may kindly permit me to appear virtually, my lord. My lord, we have filed our opposition, but we have not received any reply or rejoinder to that opposition.
Weird.
You are appearing for the respondent number?
Respondent number, my lord, respondent number 2 onwards, 2, 3, 4. 2, 3, 4, my lord. Bridge and Roof Company, India
Dr.
Limited.
B.N. Gogoi, Learned Counsel, appearing on behalf of the petitioner, has submitted that they have filed an affidavit in reply to the affidavit in opposition filed on behalf of the respondents, full stop. However, Mr. Your good name, sir?
Kanishk K. Kejriwal, my lord. Kanishka Kejriwal.
Appearing for the respondents number 2, 3,
4.
4, submits that he has not been supplied with a copy of this said affidavit in reply. The affidavit in reply is, you have filed it when? On 18th of September?
18 September 2022.
Dr. Gogoi undertakes to serve a copy of the affidavit in reply filed by him to the Learned
Lord,
Counsel appearing for the respondents by.
I apologize, my lord. I apologize, my lord. My lord, I misunderstood my instruction, my lord. There was a supplementary affidavit which has not been served. But the reply I'm instructed.
Who filed?
They filed on supplementary in the month of March 2025. Perhaps my learned friend is not not able.
You are appearing for whom?
I am a local council, Maharaj. I am
His name may be reflected. Otherwise,
yes, Maharaj.
Okay, that is.
We have received-
Counsel appearing for the respondent number 2, 3, and 4 submitted that they have not been supplied with a copy of the supplementary affidavit filed by the petitioner. Full stop. You have got the affidavit in reply.
We have received one. We have received, Maharaj. Affidavit in reply. Very.
Learned Counsel for the petitioner undertakes to give a copy of the supplementary affidavit to the counsel existing Mr. Kejriwal.
Yes,
My lord.
List this matter again after 3 weeks on a date to be fixed by the registry. Yes. Anything
One
else?
more submission, my lord. One more
Yes,
submission, my
little
lord.
bit.
My lord, the last order of 6th of August, my lord, we were present before lordships virtually, my lord, but our name is not reflected in the order, my lord. 6th of August, my lord, your lordships will find for the respondents, none appears.
Where?
6th of August, my lord, none appears for the respondents.
At the top.
My lord, just above.
Mr. Kejriwal has made a submission that although it is recorded in the order dated 6th of August that none appears for the respondents, comma, he had actually put in appearance through virtual mode.
Grateful.
You have recorded your submission.
Grateful.
If Lordship permit me, date may be fixed. Otherwise, it is very difficult to catch and fix.
Third week of, we have said after 3 weeks, huh?
2 weeks is last week of November. If
3
possible.
weeks, once the 3 weeks goes, just remind the registry they have to put it up.
Deep levelized.
Deep level. Though authority has given me all NOC, my lord, and I've installed one, my lord, petrol pump there, my lord, mini petrol pump there, but subsequently, my lord, due to dispute from the forest department, is, my lord, we cannot be able to start our function, my lord. There are NOC and my lord, trade license, clearance report, all everything has given. Enquiry is also conducted, but enquiry report, it is page 53, my lord. This it was done by.
Are you disputing the fact that it is forest land?
No. Yes, but it is not forest land, my lord. It was Pattal, and I have also next year. It was
forest department.
As per our instruction, my lord, a joint verification was done, my lord, and it falls inside Salpara Reserve Forest.
Then that
Patta
system of
also
giving
given.
a system of cancelling the patta and giving
Yes.
notice.
Yes.
That-
Near about
that-
70 lakhs it is expenditure, my lord. All NOCs are given. Deputy Commissioner, my lord, petrol pump, IOC, all of
Mr. Das,
Lordship.
possibly some time ago there is a disposal in this court regarding land which was claimed to be forest land, found to be demarcated as forest land in the maps of the forest. There was a notification to that effect.
But earlier enquiry report shows differently, my lord. Page 53. After middle second paragraph, my lord. Just I am pointing.
Why we filed your affidavit?
Not
Paying for 10 days time, I'll file.
Subject to cost of rupees 1,000 per day.
My lord,
It's a
just
very
one
okay.
opportunity, I'll file it. Just one.
This is of 2024. He is sitting there investing 70 lakhs.
Yes.
Just 10 days time, I'll file it.
Notice in this petition had been issued on
23/9/24.
23/9/2024. And the respondents are yet to come up with a response to the writ petition. Mr. Agor Thakur has prayed for
10 days.
10 days time to file their response to the averments made in the writ petition. List the matter after 2 weeks on a date to be fixed by the registry.
Date will be given, but 34/25 also they took time, my lord. 30
Date
lots.
to be, on a date to be fixed by the registry, along with the affidavit in opposition, along with this affidavit in opposition to be filed by the respondent, Forest Department. Full stop. It is made clear that in the absence of a response to the writ petition, the writ petition will be taken up for consideration on the basis of materials available on record.
Oh, let's
Yes, madam.
A bank loan was given, not one, several, without my signature on or consent or the documents that's necessary for creating a charge on the company. So my property was already mortgaged to the company. I'm the founding director of this company. Within the family, we had founded 4 companies. Out of that, 2 companies was with this bank. Still is with this bank. And I have not been living in India at that time when this happened. So that is coming to page number 12 and 13, para 11. I have listed out the documents that is necessary for creating a mortgage. Thereafter, I was trying to keep this going despite all the documentation that went on between me and the bank to and fro. However, on the intervention of the banks and the other directors, the account was made NPA. I was not allowed to pay. I was removed from signatory and everything. And then they went to DRT. When they went to DRT, that is when I understood that my signature was also forged. Thereafter, I made an application, sent for FSL, and the report came in my favor. And thereafter, they withdrew that petition without me getting all the discharge. They withdrew that. They just withdrew that petition.
Before the DRT.
Before the DRT. The mortgage, some of the amount has been repaid, some still stands. My property is still in mortgage, and I'm still tied up in a very illegal way to this illegal loan through my company and my personal property. So thereafter, I have made only very basic 4 prayers for them to first to submit. They should bring on record all the documents that is necessary to create a mortgage. And my property actually should be released. My credit score should be rectified. Because I have been trying to repay this loan for the last 10 years. I have gone through immense length. I've only given a portion of the documents here. And this is a nationalized bank with whom I have been banking since I was major actually. That was last 25 odd years I've been banking with them.
So your prayers are that they should deposit before this court?
The list of
title deeds.
Loan documents, number one.
Number one is copy of application of loan. Number two is title investigation report. That is called
But,
TIR.
even if they deposit it to this court,
Yes.
what happens?
Then it will be established that I had not signed any of these documents, which is necessary, mandatory to create a mortgage. Thereafter, appropriate measures can be taken for giving relief to me as per my prayers.
Which are the prayers? That is what I'm asking.
The prayers are
Where does it-
listed out in page 26 and page 26, 27, and 28.
I'm seeing that
But
one.
Very,
The
very.
first is for they're placing on record, placing before this court certain documents.
Yes.
We can direct them to do that. We can ask them to get on all the records before us.
Yes.
Thereafter,
Once we produce those records, the evidence is before the court.
Absolved from the liability.
this is
Absolved
something.
from the
This
liabilities.
is something.
The Lordship, it's a declaratory suit.
It's not a suit. It is very much a writ because they are a nationalized bank. Number one. Number two, they have responsibility towards their customer.
Yes.
I am their customer. And they
When
have
you say that, madam, that is when I think the jurisdiction goes off. See, even in private educational institutions which are giving education, when the issue is one between the school authority and a particular teacher regarding a service matter, the writ court is off bounds. But when it is a matter of discharging that particular education, the writ court can come into. Here is a case where you are asking for something to be done by the bank qua you, not qua the public, not in discharge of public duty.
there is
It's in private agreement.
no, it is, I will just come into this. There is no breach of agreement here. There is a general agreement.
It is not required to be a breach of agreement, even if there is a duty of the bank to do something.
Yes.
That is towards you, which has been violated or which has not been done.
No,
This is not in the public discharge of duty, is what I'm trying
No,
to say
they have
for us to come in.
no, there is a public disobedience as well in here, in the sense they have breached they have violated the norms of the company as well. So they have they have
That is
not only
between you
violated.
and the bank.
No, it's not between me and the bank
It is
because
not
there's a
between
third
the-
party. There's a company involved in here.
So even that does not come into the come into when the writ court is when this court is exercising writ jurisdiction.
It does.
And
Reason
also
being-
41 to 42 of Companies Act, mismanagement of the company.
No, that I have beg to differ from him because mismanagement of the company is towards the holding the company liable. But here I am holding the bank liable. I need to find out if
The
a
only issue that
nationalized
we are
bank-
trying to find out is that whether sitting in a writ court.
Yes, because they are accountable. Here, public accountability is what we are trying to bring in. So public accountability is what they are going to have to establish. And not only that, last 4 days, they have said that they will be filing a reply.
Yes, your affidavit is in.
No, Your Lordship, it is not there on the last occasion. I've
Did you
sought
take
some
time?
instructions.
Yes, they took time.
Did you take time earlier occasions?
The order reflects so.
Your Lordship, on the last occasion on 8/9/2025, I need some time to complete my instruction because on that day I have not gone through the petitions fully. So now I have gone through, then I come to know that this writ petition is only against the enforcement of the private contract between the parties.
I do
And
not
number two, Your Lordship, that declaration of mortgage as a fraud, I do not think so.
Is
that
is it your stand today that you would argue without an affidavit in opposition?
No, Your Lordship, if help.
Requirement would
Yes,
be.
Your Lordship, I'll file.
Would it be upon us to press
Yes, Your.
for an affidavit in opposition?
Yes, Your.
Yes.
Yes. I need
We
to
should
file.
press you for an affidavit in opposition.
Yes, sir. But on the preliminary issues, I think that this
Repeatedly,
matter
yes.
may be decided, Your Lordship. If on the preliminary issues, it would be decided because
Raise
the
the
prayer.
issue, she would reply to it. Unless you come up with an affidavit in opposition, she would also not know what you are.
So, Lordship, 2 weeks maybe.
Public interest is is the core, at the core and the crux of the matter. On what basis they are creating mortgage on people's properties, and in turn also on the people. We need to know that.
heard Ms. A. Saikia petitioner in person. The earlier order dated dated 8th of September 2025 records that the claim was sought for on behalf of the respondent bank to complete instructions. Today, Mr. M. Sharma, that is pending counsel UCO Bank, submits that he would be filing an affidavit within a period of 2 weeks. 2 weeks. Full stop. List this matter again.
A date maybe. I pray for a date, yes.
The difficulty will be this one. You have to let us complete the order. List this matter again after 4 weeks.
2
The
weeks
date
they
to
prayed
be-
for.
On a date to be fixed by the registry, comma, allowing the respondents to file their affidavit in opposition within a period of 2 weeks and allowing a further period of 2 weeks to the petitioner to file her rejoinder, if any, to the affidavit in opposition filed by the respondent bank. An attempt would be made to dispose of the writ petition. No, an attempt would be made to decide the issue of maintainability of the writ petition as raised by the learned counsel for the UCO Bank on the next date. We'll decide the issue on the
We'll
next
decide
date. Then after we can proceed with these.
Much.
May I, Mr. Lord? This matter pertains to composite land transfer matter. Due to rate file is due to non-issuance of NOC. My lord. What happened, my lord? I applied for NOC being a seller, my lord, on 9/2/2024.
Lordship,
And
in this case, Lordship, we have received certain instructions, but certain instructions is required, Lordship.
my
That is because we have received one instruction that the e-stamp in the affidavit, first party and buyer both was mentioned as Raju Ray. But I have not find that document, Lordship. We have to bring it.
If there's something wrong in the, look at his first prayer. If you,
Lordship.
the first prayer that is made,
Yes.
prayer number 1, page 10. It's either 1 or it is 2. We can
Issuance of
allow only 1.
NOC for transfer of land of the property.
No.
Petitioner.
Dispose of the application dated 9/2/2024 at page 10, number 1.
Dispose of the application to the change of or issuance of NOC for transfer of land of the property.
If we go on to decide on your instructions as to whether this document is, can we do that? This is necessary, that is not necessary. Can we accept or reject it?
Lordship. Now, my lord, it is rejected recently.
It has been rejected.
Rejected.
Then you challenge that.
My lord, I have filed additional affidavit, my lord. Kindly see the matter. My additional affidavit, kindly go through what happened. I have.
In that case, he has to file a fresh application.
Unfortunately, your suggestion to take up the new fact as an additional affidavit and then continue with the repetition, several persons are shaking their head behind it. Not done. There is a change in the circumstances to the extent where the prayers have to change. Some submissions and statements in the repetition has to change. Either you amend the whole thing or you withdraw this in view of the later on developments with the liberty to challenge whatever has now come into it. What do you want?
My humble submission, just for a moment, my lord. They may file because we have, my lord, we have taken on tracking the application, just have rejected, nothing else. Now, my lord, learned counsel, my lord, the respondent saying that there are some reasons that we should know, my lord.
Initially,
What-
their prayer
what
was
reasons?
different.
Because
Now
the
this
reasons
prayer
we
is
don't know,
different.
my lord. Ultimately, again, they will show some reasons. After 1.5 years, now they rejected when the read
Mr.
H.R. Chaudhary.
Mr. H.R. Chaudhary, learned counsel appearing for the petition. Also heard Mr. H. Sharma, learned counsel appearing for the respondent number 7. So Mr. A. Bhattacharya, learned counsel appearing. Respondent number 1, full stop. although the respondents are yet to file their affidavit in opposition in the matter, comma, the learned counsel for the petitioner has submitted that while the prayers in the writ petition was with regard to prayers in the writ petition was for directions to the respondents to consider and dispose the application filed by the petitioner seeking NOC for sale of his land and or other directions requiring the respondents to issue an NOC in favor of the petitioner, comma, during the pendency of this writ petition, the application filed by the petitioner has come to be rejected.
Reject.
The said rejection has been brought on record by the petitioner by way of an additional affidavit filed on
my lord.
24th of September 2025.
Yes, ma'am.
Is it?
Yes, 23rd of September.
23rd
of September.
4th of September 2025. Full stop. On a pointed query by this court, the learned counsel for the petitioner has sought for some time to seek instructions whether he would like whether the petitioner would like to pray for an amendment of the writ petition in accordance with the procedure laid down, or would like to have or would like to withdraw this writ petition with liberty to say the further developments which took place after the writ petition, allowing him to analyze the matter after 6 weeks, allowing the petitioner, allowing the prayer of the learned counsel.
A short date may be given within this time. By this time, I'll take it.
We gave you the option today.
Why?
Yeah.
35.
Yes.
Wait, please, Lord.
Yes, sir.
There's some problem with my repetition, my lord. I want to do it with liberty, my lord.
We don't have to record what is the problem. We don't have to record what is the problem. We'll simply say you want to withdraw it in its
My lord, problem is this, my lord. It is in the order dated 28/25. It is pointed out that there is some dissimilarity of father's name of the petition.
Mr. M.A. Sheikh, learned counsel for the petitioner, has submitted that he is under instructions of the petitioner to not to press the writ petition in its present form, since there are some discrepancies which would require rectification, and he therefore prays that he may be allowed to withdraw the writ petition with the liberty to approach this court again. Stop. Liberty as prayed for is granted. Writ petition is disposed of on withdrawal.
Right.
Writ petition allowed to be withdrawn. Liberty as prayed for.
Also, in this case, the last order, the circle officer, respondent number 1, was directed by this court to take instruction regarding the demarcation of pillar, Your Lordship.
Demarcation pillar.
Yes, Your Lordship. Some demarcation pillar have been set up by the circle officer, Your Lordship, and our contention is that that is our property, and we have been informed that
it is inside your property.
Yes,
the
sir.
Demarcation pillar falls inside your property.
Yes, Your Lordship. And then the NHA has given affidavit in opposition when they are saying that it's not been acquired by NHIDCL, but the demarcation pillar still is there, Your Lordship, in today. And no, we have not got any instruction on that, Your Lordship. So,
on behalf of
Are you inside his property?
No. It cannot be, my lord. This is the not. Anyhow, this will be clarified by the Kala. Kala means with the help of circle officer.
Yes.
Whether it has been discerned. We are only requiring agency.
We are awaiting the instruction.
Huh? But they must be digging big holes in his land by now. No, not yet.
We have not received any instruction. So,
I mean, next the photography page number 103, Your Lordship, with the
regarding that pillar,
Huh?
we have written a letter, Lordship, but we have not received any instruction. Can I report?
Mr. A. Sharma, learned, heard Mr. R. You are Mr.
J. Das.
A. Rai, huh?
J. Das, your lord.
J. Das. Mr. J. Das, learned counsel appearing for the petitioners. You, will you file an affidavit in reply?
We are getting the instruction of lordship. We will take some time to file.
Mr. J. Das, learned counsel appearing for the petition, who submits that he may be permitted to file affidavit in reply to the affidavit in opposition filed on behalf of the respondent number 1 and 2.
1 and 2.
Mr. H. Sharma, learned counsel appearing for the
6, 7, 8 and 9.
6, 7, 8 and 9. Praise for some further time to file the response to the writ petition. So who appears for
1 and 2 I am appearing.
your affidavit is filed already?
Yes.
3. You would not file your affidavit? Will you file it?
No, this is not required actually. We are
Respondent, counsel appearing for respondent number 3 has submitted that they would not be required to file an affidavit. Yes. Then 4, would you file? Not required. Now, similar submission of non-requirement of filing of a response to the petition has been made by the respondent number 4 on behalf of the respondent 4 and 5. So 8, 9, no, number 10, who is 10?
The performer respondent is my sister, your lordship. She's married.
Has she been served?
No, your lordship, not been served. Actually, it's not required because we are right now in possession of the property, the petitioners.
You have made someone a respondent.
Yes.
Can you stand up to say no, not required to serve her? I'll fight on her behalf.
Also, we are informing the court, actually, lordship, that she is also one of the.
Once a respondent.
No, my lord. If so, with last stage of hearing, performer respondent when it is no religious, he has to say here that I don't have any grievances. He might have grievances, then he has to agitate. Once made party, the return has to go there.
Sir, even he knows that.
No, that's correct.
For a
last moment,
nudge from you.
Last moment, Miller, it will make a problem for us.
You have not given the proper address of respondent number 10. You have shown her to be residing in your same house. Why has she not joined you as a petitioner? End of the day, this will cause a problem in the disposal of the.
I'll take the instruction and inform the honorable body, lord.
Right. The counsel for the petitioner would also take instructions as to why. Notice issued. Notice was issued. Or respondent number 10 notice was not issued. That will cause you a problem later.
That's a
Allowing the parties to file their respective affidavits. List this matter again after 4 weeks on a date to be fixed by the registrar.
Date may be fixed, your lordship. And date may kindly be given.
After 4 weeks on a date to be fixed by the registry.
Oblige, your lordship.
Issue, my lord. Land transfer, my lord. NOC.
In this matter, my lord, instruction has been received regarding rejection of their application, my lord, on portal, my lord.
Their NOC has been rejected.
Rejected, my lord. In that matter, my lord, coordinate bench has already decided one judgment, my lord, WPC 171025. Where that requirement is to pass a speaking order under the RTPS. And inter alia, court has directed the respondents to pass a speaking order regarding my lord.
Your rejection is not speaking. He does not know the reason.
It's on portal, my lord. That instruction I have received.
No, that judgment you have. Why don't you give him a copy? We'll have it up after a week. Take a look at the judgment since it has already been rejected.
That instruction may be.
Instruction is
Miss heard Mr. So-and-so learned counsel appearing for the petitioner. Miss M. Borman learned counsel appearing for the respondent has submitted that after the during the pendency of the writ petition, the request of the petitioner for issuance of an NOC has been rejected, and that in such circumstances the judgment and order dated so and so passed by this court in WPC number so and so would suffice the grievance of the petitioner. Full stop. A copy
Judgment
of-
in order dated 3/4/25, WPC 1710/25.
1715
1710 2025.
disposed of on
And 3/4/25, my lord.
2025. Full stop. Learned counsel for the petitioner is given an accommodation of 10 days to go through the judgment and order and see if the subject matter of the petition would be covered by the said judgment and order. A copy of the instruction
May be kept on record.
produced by Ms. M. Burman is kept on record and marked as an extra X.
This is
This
also
is
the
also similar.
composite.
Here, Parawise comments reflected that it is rejected, my lord. So same order.
Same order.
Same order.
Same order. Abo,
It may be kept.
same order. That it can lead a instruction marked as X. Okay. Did I not see? Yeah. Mm. Yes, sir.
Milord, in this case, Milord, out of 10 ward members, Milord, we are the 6 ward member before this honorable court, Milord. In the first meeting, Milord, 27/2025, Milord, the petitioner raising their hands in favor of the petitioner number.
Affidavit filed by 4 and 8 and 9.
Yes. So all respondent file affidavit. Milord.
Okay. So you want to file replies?
Actually, Milord, in this Milord, government Milord, for district commissioner file affidavit in reply, Milord, respondent number.
Would you like to file a reply, sir? No. If not, then we'll take it up for disposal.
Milord, who need to reply file?
Okay. And yes, what is your prayer?
Yes, Milord.
Is it short enough that we can finish?
And next week, Milord, any date, Milord, short date. Respondent number 8 and 9 illegally functioning the president and vice president without authority.
What is the illegality?
Illegality, Milord, as per section 46(6), Milord. No election was held, Milord. No election was held, Milord.
No election was.
No election was held in respect of the president and vice president, Milord. And in this case, Milord, a petitioner was ousted from the office by the respondent number 5, Milord, circle officer, Milord, which is admitted by the respondent, Milord.
Where do they admit it?
Para 9, 10, 11, 12, Milord. There is no comment. Milord.
Affidavit by respondent number 4.
4. 4 district commissioner, Milord.
Where it is admitted?
Milord. Para 9.
Para 9.
9,
It is not
10.
true.
Yes.
It is not true. How is it admission?
No, kindly see para Milord 5 of affidavit, Milord.
No comments.
No comments.
Huh.
No comments means, Milord, it's admitted.
Mr. Sharma? The no comments is being read as admitted.
According to my learned, refrains from making comment as because he has got no knowledge regarding that law. But selection was done, Lord.
A selection among the 4 ward members.
That's because meeting was held on that day.
A meeting was held, Milord. Meeting was, Milord, prior to meeting, Milord. All the petitioner and respondent are signing on the proceeding as per section 134, Milord. Oath was
If my
taken.
learned friend wants to file a reply, in that case, Lordship,
He said it will not be required.
in that case, Lordship may fix it for final disposal, Lordship, any other.
Yes, the affidavits filed by the respondent number 4, 8 and 9 are on record. When the council paying for the petition has submitted that he would not be filing an affidavit in response to the affidavit in opposition and the matter may be taken fixed for disposal.
Yes. 11
Stop.
million. 11 of this month.
Release this matter after 2 weeks. When date to be fixed by the registry, where an attempt shall be made to dispose the.
A date may be fixed, my lord. A date may be given by my lord.
2 weeks. Date to be
Otherwise,
fixed
my
by
lord,
the
I have
registry.
to mention before this honorable court again.
You mentioned it before the registry. You tell them it was 2 weeks. 2 weeks. That is
Okay.
our order. Date to be fixed by the.
For that, my lord, 10 days, my lord. After 10.
Not possible. We can accommodate, we are trying to accommodate wherever we can on appropriate methods.
Okay.
39, yes. Notice in this case was issued on 1/11/2017. Full stop. None appeared for the petitioners from the next date of listing, that is on 29/1/2018. The office notes of the Loazima court reflect that the petitioner has not taken steps for service of notice upon the respondent number 5 as directed. So, it appears that the petitioner is not interested in pursuing his cause. The petition is dismissed for non-prosecution.
Wait, please, Lord.
Yes.
Well, kindly peruse the order dated 30/10/2025, madam. Law of Jima Code for. So for service of notice upon respondent number 6.
The order dated 30/10/2025 of the Loazima Court reflects that that the notice has been delivered to the address of the respondent number 6 on 26/8/2025. However, today there is no representation on part of the respondent number 6, although notice is appropriately served at the address given in the writ. List again after 2 weeks. The date to be fixed by the registry, awaiting appearance on behalf of the respondent number 6. The official respondents shall be at liberty to file their response to the writ petition in the meantime. It is observed that the writ petition is of 2017 and no further time will be given to the official respondents to file response.
How like it?
Maybe, Your Lordship.
Yes.
As per Loazima Court order dated 1/11, my lord. Service upon respondent number 6 is complete, my lord. Matter may be come up for admission hearing, my lord. Yes, ma'am. Government filed every one.
File. Will that suffice? What is the
Cases, my lord, petitioners, thus land was acquired, my lord. But the entire amount has been paid to the petitioner and another other brother, my lord. Despite petitioner filed objection that his share should be paid to him, the entire amount has been paid to his brother, my lord. That's number 6.
So why don't you claim it from the respondent number 6? Why claim it for the government again? Where are they going to pay again and again?
I filed a objection before the district. Before
you made a mistake. Now who is
before disbursal, my lord. Now paragraph 10, the
You said no objection.
I have not said, my lord.
Who said?
Other sisters, my lord.
Sister said no objection. Pay.
No
him.
objection. Pay him. But what about my share, my lord?
Your share you take from your brother. Why should the
He
state
will not
you?
pay, my lord.
Huh?
After getting this, he will not pay to me, my lord. That is why I objected, my lord. And my on my obligation hearing was taken, my lord.
Hazrat Ali, you did not appear.
I was appeared, my lord.
You appeared, you
Yes.
filed, you objected that
Yes,
day
yes,
also.
yes,
Yet the government went ahead to pay.
Yes, my lord. Yes, my lord.
Office note dated. Where is that law Azima order?
111.
Sorry, law Azima order dated 1/11/2025 reflects that the notices with regard to the respondent number 6 has been served in the address given in the writ petition. However, there is no representation on behalf of the accused. The state respondents filed their affidavit in the matter placed again after 3 weeks on a date to be fixed by the registry, awaiting the appearance of respondent number 6. Since the respondent of state authorities have already filed their affidavit, the petitioner would be at liberty to file reply, if any, within the appropriate period. Yes.
Obligation.
Yeah, my lord, I'm appearing for the respondent number 2, my lord, the district commissioner, Marigaon, my lord, Debasis Borwa. Sorry, Debasis Sarma. My lord, I have produced one letter, my lord, whereby my lord, the sanction order has been issued, my lord, in favor of the my lord, son of the petitioner, my lord.
Why not to the petitioner?
My lord,
Petitioner.
my lord, sorry, my lord, it's a
Just talking of the deceased.
petitioner, but name has been mentioned that Biras Deuri on behalf of my lord, 2. Yes, Bhagala Deuri, my lord.
Yes, I think it is 5/2/2015.
My lord, sanction.
This was sanction order. Was it disbursed?
It has been disbursed by.
That information regarding his lordship, I have a very conflict.
Hmm.
Kindly give me some time. But we-
Because if it was not disbursed, then the sanction has lapsed.
Exactly, that
There has to be a fresh sanction.
February's sanction order.
Miss Udas, counsel appearing for the petitioner number
Respondent number
or for the respondent number 2 has submitted a document on a sanction order issued on 5/2/2025 sanctioning an amount of rupees 2 lakhs in favor of
Next of king of the deceased.
Madam, my lord,
Next of king of the deceased.
petitioner of the petitioner in favor of the petitioner in this contempt petition in compliance of the orders passed by this court. Miss N. Bodolo, learned counsel appearing for the respondent number 1 has prayed for some time to find out whether disbursal of the amount had been made in accordance with the said sanction order. Full stop. Learned counsel for the petitioner has no instructions whether the
I have instruction, he had not received.
they have not received. Cut out that one. List again after 2 weeks on a date to be fixed by the registry. Full stop. It is made clear that the respondent number, if the stand of the if the respondent number 1 takes a stand that the money had not been disbursed despite sanction having granted on the 5th of February 2025, he shall also furnish appropriate instructions as to why the money could not be disbursed after sanction had been dead.
my lord, whether your lordship will keep it in a record, my lord, my instruction, my lord.
A copy of the instruction submitted by Ms. Udas is kept on record and marked as an action text. Please also have the instruction why it could not be paid
Please,
after the sanction.
Oblige.
Date may be fixed, your lord.
2 weeks.
2 weeks, date may be fixed, otherwise it will be again to mention for
No,
listing.
it will come up as on a date to be fixed by the registry.
Lordship. I'm surprised.
We have said that. Yes. 43.
May I please, Your Lordship?
Yes.
Your Lordship, by order 13/10/25, respondent of 5 and 6 was given final chance to appear here. We have served notice by through the dusty method also and filed affidavit. This is a non-payment of bill, my lord. Chairman of municipal, Nalbari Municipal Board and executive officer of the Nalbari Municipal Labor, they have not appeared till today. Order may be passed. Annexure number 5 and 6, 19 and 20. My lord,
This is
they are
what an admitted amount.
my lord, they are not appearing. We have filed bill.
What is your claim?
My claim, we have filed four bills. Earlier 2 bills was paid to us, but last two bills were not paid to us. One is for 3,06,456 and other is for 2,29,842.
Tamsher Ali, admitted amount. Dispose of.
Admitted amount.
To verify the bills and pay within a period.
Verify the bills and pay.
Admitted amount. Disposed of.
Right.
In accordance with Tamsher Ali. Yes.
Please, Lord.
Yes.
There is a miscase for restoration of the connected writ petition, my lord. And the connected writ petition has come up as a production list matter, my lord, without any mention, my lord. And I could not know about the listing of the matter. Later on 5/1 in the evening, I got the message from the registry that matter was listed. Order is at page number, my lord, 54. It's dismissed for non-prosecution, my lord. 54 is the order, my lord.
Page number 54.
54.
54 is the name of parties.
My lord.
Operative part.
Operative part 59, my lord.
And
on the cause list, my lord.
What is the subject matter?
Subject matter regarding my lord issuance of caste certificate to persons who
Notice has not been issued in this.
No, my lord.
Ah,
It was in a motion stage, my lord.
this miscase has been preferred by the applicant. Praying for restoration of WPC number
2382/2025.
to file by recalling the order dated 19/5/2025 by which the said petition was dismissed for non-prosecution. Full stop. I issue notice. Returnable 4 weeks. Chief Secretary, Social Justice Empowerment. Next one. Higher education. For 4, so and so appears for respondent, opposite party number 4. Mr. Hazarika, for respondent number. Hmm. 15. Okay. One who appears for one chief secretary. He'll also appear for one also. Note kori ase ne? 2,
3 and 7.
3 and
7.
7. For 2 who appears? RM. RM does for respondent number 2. Then petition since respondent number so and so are represented, formal notices are dispensed with, extra copies within a period of 3 working days. Steps for service of notice on 14 15, 16, 17, 18, 19, 20, from 14 to 35 by way of
Speed post.
speed post within a period of 7 working days from today. List taken after 4 weeks along with service report. Official respondents, give them copy. Yes. Yes.
May,
Yes, sir.
may I please, as your lordship, my lord, in the IA, my lord, a notice of eviction or demolition, my lord, is before my lordship, my lord. Is at page 41, although the notice is of 2024, my lord, though no interim order is operating, but till date, my lord, they have not acted upon. We have made a reply, my lord, to this notice. My lord may be pleased to find that reply is at page 42, my lord. First of all, my lord, this notice says that there is some deviation or violation of the, my lord, structure wherein we are, my lord, my family is residing, my lord, the petitioners, my lord. My lordship, original building was gutted in a fire, my lord. And that building, my lord, that building, my lord. Now, my lord, after the gutting of the fire of that building, my lord, we are now somehow.
Some orders, some interim orders in the repetition.
In this, yes,
In the
yes,
writ
yes,
petition?
yes, in the writ
By the
petition,
writ
interim
petition?
order is there, my lord, I have annexed that.
By the
My lord may be pleased to find in my IA also, my lord, that, no, it will laptop here, Fakhruddin building. My lord can find it at page 24, my lord, starting at page 24. Can skip the first page, my lord, the interim order is at, my lord, page 25.
Mr. Nair, there
F.
is an interim order in the main writ petition, lordship, saying that the respondent authority shall not demolish any structure standing over the plot of land without serving proper notice of demolition upon them. Now they have been served a notice of.
In the present case,
Ha. In
there is
the
another matter, lordship, that is 5026/2022.
that is also listed with.
No, no,
together.
that is listed today.
Yes.
That is listed today,
also
my lord.
listed
That is listed today, my lord. Perhaps, my lord, 2 writ petition has been filed, one of 2025 recently, my lord, that notice has been issued. That is regarding, my lord, a plot of land in Rihabari, my lord. Now, this is a, my lord, area in
Item
Lakhpatia, my lord.
45 today is an IA in WPC 5026
My lord.
of
2022, my lord.
In this writ petition itself, there was an interim order saying that the structure shall not be demolished without giving them a notice.
Lordship, presently we have issued a notice.
Now you have issued a notice, they have asked for an interim stay on that notice pending disposal of the writ petition.
My lord.
Once the demolition is allowed,
No,
during
I'm
pendency.
not, I'm not saying that straight away we are going to demolish the construction lot.
He has given a reply.
So let him find a reply.
He filed it.
So let us decide, Lord. Let us decide.
But then, even then, if you go ahead to demolish the building during the pendency of the writ petition,
Lordship, let us on the
then
basis
we'll
of
do it this way. We'll give you the liberty to decide on the reply and not demolish it without the leave of the court.
My
That do?
lord.
This IA has been filed by the petitioner challenging an order and a notice dated. Where do we find that page?
My lord, page
29/11/2024 issued by the Office of the Guwahati Municipal Corporation, Dispur, Guwahati, by which the petitioner has been
to remove or pull down
directed to remove or pull down the unauthorized the alleged unauthorized construction described in Schedule A of the notice itself. It is the Learned Counsel. The reply filed by the petitioner has also been brought on record along with the IA itself. Full stop. It has been submitted by Mr. A.R. Bhia, Learned Counsel, appearing for the petitioner that in the main writ petition there was an interim protection granted to the applicant herein that no demolition of the premises of the structures in issue would be carried out without giving the petitioner a notice. Full stop. By this interlocutory application, he has prayed that if any demolition is allowed to be carried out by the respondent authorities pending during pendency of the writ petition, the subject matter of the list may itself suffer. Full stop. Mr. P. Naik, Learned Additional Advocate General, appearing for the opposite parties herein oblique respondents in the writ petition. Official respondents in the writ petition have submitted that the department has to take a call on the has to take a decision on the reply filed by the writ petitioners to the notice served upon them. Full stop. And till such decision is taken, there is no question of effectuating any demolition of the premises, of the structures. Full stop. This interlocutory application is therefore disposed of by giving liberty to the respondent authorities to take a decision on the representation filed by the petitioner applicant to the order of demolition served upon him. After making such inquiry as may be necessary, full stop. It is further provided that demolition of the structure standing on structures in issue in this writ petition shall not be made without taking leave of the without obtaining leave of this court.
Served upon her, my lord. Not him.
He oblique her.
I think in this.
We are disposing the interlocutory application, directing you not to demolish it without taking leave of the court. But you may dispose of his representation in the meantime so that it helps in the writ petition.
I think in this matter, Lordship, we have already issued the 337(3) order, Lord.
That order he has made a representation.
Lord, there is no scope making a representation after.
Then we have to then if during pendency we direct him to break
Stay
it
of the
down.
order.
The entire suit to the entire writ petition goes. That will lead to some.
Lordship.
Let the writ petition come up for decision. If the pleadings are complete.
Lordship. In the IA, Lordship, I filed one objection.
You have filed.
In the IA, yes.
No.
The IA, yes.
You file an objection. It was not brought to notice.
Yes, my lord. Rishiraj Sharma, my lord.
In any case, we have said that you may take a decision on that representation and not demolish without leave of the court. Let the matter be decided.
Obliged, my lord. File over.
A notice issued, my lord, on 35/25, my lord. Caste certificate was not given, my lord. Hearing was
All respondents represented affidavit filed.
Sole respondent is there.
Sole respondent.
But I'm hearing.
Ah.
But I have one communication, but the direction of the honorable court kindly come to page 16.
16.
Lordship has directed that before entering.
Application has been made.
Before entering into the merits of the case,
They made applications thereafter.
they made
What happened?
applications, and my instruction kindly see, Lord, they were heard, petitioners were heard, and ultimately the records have been forwarded to the Commissioner and Secretary, Department of Tribal Affairs, please.
It is under process.
They filed the applications. Kindly see, Lord, I have the honor to draw your kind attention. This is a letter by the respondent herein to the Commissioner and Secretary, that kind attention to the instant matter disposed of by the honorable court. So and so the direction has been quoted. That being so, the petitioners appeared before this office with all relevant documents in support of their respective claims. All the petitioners were heard individually, photocopies being enclosed, and also reports were collected from Circle Officer, Hajo Revenue Circle, and President Secretary, Uttar Kamrup.
They are
Jilla
asking for
Caste certificate.
caste certificates.
Caste. As per,
That will take the due, that will be under the procedure by law.
yes. That has
When
to
did
be,
you applied after the writ petition was disposed of?
No, initially, my lord, as there was my lord, it was on the basis of papers, my lord, only.
Ah.
Forefathers were, my lord, there, my lord, but there was some,
No, the orders of this court was that you would
third para.
appear,
Kindly
you would
third-
make an application, and as and when such applications are filed, the concerned authorities,
will consider.
and within 45 days from receipt of the application. When did you receive the application?
But this is the forwarding of July 25.
Hmm,
Ultimately, after hearing,
August. September. Time gone.
no, it was 24, May 2024.
Ah,
The honorable court order was in May 2024.
no, from date of receipt of the application.
Lordship.
Now, applications were received, so be it. Your instruction is of 24/7/2025. You are
July-
yet to take a decision on the applications.
But in fact, my submission is, below the deputy commissioner who is party here, he has already done his part and sent it to the commissioner secretary. Commissioner is
Sole
not-
respondent.
sole respondent. Commissioner
No,
is not a party here.
No, we find three.
Look.
We find 3 persons.
I'm for the respondent number. I'm for the respondent number
Who appears for 2 and 3?
1.
Who appears for 2 and 3, sir?
But they are the Commissioner Panchayat and Rural Development and President Uttar Kamrup Jilla
at the relevant point of time, she was, my lord.
Hmm?
At the relevant point of time, my lord, commissioner, she was, my lord, deputy commissioner.
No, how can Panchayat and Rural Development Department give you?
No, my lord, she was, my lord, Kirti Jalil was initially, my lord, deputy commissioner. At the relevant point of time, they are in the Kamrup Amingao.
Okay, and
That is
Golok
why-
Chandra Das?
Golok Chandra Das is the president of Uttar Kamrup Jilla Anusito Jati Porishad.
We have to close this contempt petition. The deputy commissioner has forwarded it, done what they could.
Then, my lord, I'm allowed to implement, because my lord, direction was only to the deputy commissioner, my lord.
Mr. D. Nath Learned Council appearing for the respondent number 1 has produced a document, an instruction dated 24/7/2025 before this court, which depicts that after the petitioners had made their applications, appropriate steps were taken by the District Commissioner Kamrup Amingao to have the matter forwarded to the Commissioner and Secretary, Department of Tribal Affairs, within bracket claim, D Block, 3rd floor, Assam Secretariat, Dispur, Guwahati, full stop. Insofar as the present respondents are in this contempt case is concerned, this court is of the prima facie view that they have done, that the District Commissioner Kamrup has done what was in his power to comply with the orders of this court. Full stop, Mr. So and so wants prays for some time to have his instructions with regard to the compliance of the orders, whether the certificates have been received by the petitioners.
Not.
And have further instructions. No, then we close it.
In fact, my lord, the notice was issued.
Since the respondents in this petition have complied with the orders of this court and there are no other respondents, we do not find any contempt.
No, my lord, I am implementing as a party respondent, my lord, this, my lord, petition, respondent number 1.
Notice was issued to respondent number 1 by 35.
The other respondents cannot comply with it. Mr. H. Das, Learned Counsel for the petitioner, seeks some time to have his instructions on the compliance of the orders of this court, list accordingly after 3 weeks on a date to be fixed by the registrar.
But my instructions may be kept on record.
The instructions placed by Mr. Dina is kept on record by Mark X. Yes.
Okay.
Maybe your lordship. regarding the matter is
Oh, yes,
Yes.
that content shop.
and the latest photograph of yesterday. It's still there with it's time stamped and everything. I waited till 1 o'clock there, at least till 1 o'clock they will comply or something. Then I
Yes, sir.
In my humble submission, there is no context. I'll show from the orders. Lordship may come to page 11 first.
Yes.
The initial order was passed on 17/12.
Hmm.
Lordship is aware.
Hmm.
And the modification was on this day, 18/12, by this order. I guess Lordship straightway come to the operative part of the order at page 16, well,
Huh? 16.
16.
Yes.
14 paragraph 13. Therefore, liberty is granted to the petitioners to file appropriate application for arraigning him as a party, if so required. However, considering that the tenancy agreement is still in force and in view of the discussions made above, respondents number 3 and 4 will also ensure that there is no obstruction of entry and exit to the tenanted premises belonging to the petitioner from the southern side also. In view of the order passed today, the order of 17/12/2024, more particularly the direction at paragraph 8 of the said order, will stand modified to the extent that GMC authorities will issue notice to the said so and so, if not party already issued and thereafter, upon due verification shall decide on the aspect of grant of trade license to such a person to run the shop at the same premises.
That
where
we have read, Mr. Mazumdar, can we come to 17? Para 17.
17, yes. In fact, I wanted to read 17. The
3 and 4 will
ensure
yes.
the removal of the obstruction on the eastern side.
Eastern and
ensuring entry and exit through the southern side.
Yes.
Within 3 days from the today.
Yes.
Without affecting the kiosk of Muhammad Alam. So the kiosk will remain. Kiosk on the southern side will remain.
Where is the kiosk? Is the kiosk the only?
Well, I'm coming. Now the kiosk has been removed by the GMC subsequently. Lordship, give me just a couple of minutes when I clarify it. So now, Lordship, kindly turn to page 11, man, of their petition. Page 5. Page 5, paragraph 6.
Any affidavit filed by the contemners after receipt of notice?
And yes, ma'am.
No.
Affidavit has been
No. No affidavit has been filed. This contempt petition was filed long time. Till date they have not filed. They are this border.
And this affidavit in opposition is by whom?
This affidavit
1 and
was
2.
No, contemners have not filed. There is a connected writ petition. Connected writ petition. There is an IA. They have filed.
What is page 35 contempt case? We are seeing an affidavit in opposition by Aminul Alam.
Yes, sir. I'm sorry.
And Sayeda Rehena Alam. 2 persons are swearing one affidavit. Okay.
Husband and wife.
Yes.
And Lordship, give me 1 minute. I'm verifying whether there is no. Now, para 6, Lordship, you kindly see. I'm straightly going to the 6th line. This structure from top, paragraph 6. From top, the structure which was before the shop of the petitioner was removed on 18/3/2025 night. So that kiosk was removed by the GMC. They have admitted also there was some miscommunication. Mr. Nayak appeared. Immediately thereafter, the contemners erected bamboo structure on 19/3/2025. So next day, bamboo structure was erected on the next day. Firstly, kindly see 1812. There is an order that northern side, southern side, kiosk will remain. Exit and entry will be there, but kiosk will remain. Now GMC has removed the kiosk on 18/3. 19/3 bamboo structure has been put. Now, Lord, should you kindly see page 47. This is actually part of the affidavit in opposition. The order passed in the requisition filed by the tenant on 26/3/2025. This order has been passed. Next, page 48, my lord. Third paragraph. Mr. Pathak, learned counsel for the petition, has submitted that on 18/3/2025, the respondent GMC authorities had carried out a dismantling exercise whereby the iron frame in front of the petitioner's shop had been dismantled and taken away. Now, the paragraph thereafter. Having regard to the projection made on behalf of the petitioner, it is observed that till the next date of listing, the parties shall maintain status quo existing as of today. So, if on 19/3, my lord, that bamboo structure has been put, and this tenant who is there for this, my lord, he approaches this on court in a separate.
He is the owner of the bamboo structure.
Yes, my lord. He approaches this on court.
He is the owner.
He is
If
the
you have a
tenant.
look at the name, sir.
My lord.
If you have a look at the name, he is the owner of the kiosk, which was removed by the GMC.
My lord, he is the tenant there.
He is the owner of the kiosk.
My lord, assuming for the time being that he is the owner of the kiosk, kiosk, and so far structure is concerned, my lord, Lord, should you kindly see page 26/3/25, structure has been put on 19/3. 1 minute. 19/3 structure has been put. 26/3, when the structure is already there, this from the court at the instance of the tenant says that status quo will be maintained. So the structure, bamboo structure will remain. Am I, my lord? We are, my lord. Structure has come up according to the petitioner on
At least
19/3.
we are clear, Mr. Muzumdar.
My lord.
This is taking us round and round. At least we are clear. This all had been argued on the day we passed the earlier order. This was placed before us. We spent around half an hour going through every part of the order, trying to find out every nook and corner as to how we can say that the contempt has not been committed.
My lord,
We had made it very clear in our last orders that unless the structures are removed and the shop is allowed to,
my lord, there is one more aspect.
we will have, and it was also submitted to us that the petitioners, the respondents may not be in town from 2 or 3 days,
They
therefore
are
things will be taken care of in a day or so.
Well,
We are not satisfied.
Well, just give me a couple of minutes. I'll just clarify.
Contempt jurisdiction, perhaps. Yeah,
Well, I'll see the contempt. So, Lordship has seen, my lord, on 26/3, according to them, 19/3 bamboo structure was there.
Yes.
On 26/3, the tenant comes before the Supreme Court, says that I have got
The owner of the kiosk in front of their shop comes. Let us not confuse it with the tenant. The tenant is he.
My lord, assuming
The tenant is not Mr. Mahmudul, the earlier order, which required the removing or staying of the kiosk.
Yes, ma'am.
That was Mr. Mahmudul as recorded in the order. So Mahmudul cannot become a tenant overnight after the order. And if that has been allowed to happen, then he gets into further trouble.
No,
The
my lord.
response-
What-
contempt
my lord,
of-
assuming for the sake of argument, assuming for the sake of argument that bamboo structure, the owner, that is respondent in the contempt petition, they have put, assuming for the time. On 26/3, admittedly, that bamboo structure was there, my lord, as per their own admission in the contempt petition. So in 19/3, this bamboo structure was already put. And this projection was made in the writ petition.
So
on
if we go by the projection made in the affidavit in opposition and the projection that is now being sought to be made, we would have to understand that there was already something covering
Yes.
that shop on one side and the obstruction already existed on the other side also.
No, my
Both
lord.
the sides were covered up.
No, my lord, Doctor will kindly visualize one. So far as the agreement between the parties are concerned, eastern side, it is like this, my lord. This is the west, north, my lord. So market enters this way. This way. Northern side is totally open. People have to enter. His shop is on the left hand side. Left hand side or
Right hand
It's,
side.
it's like evident on the picture, everything is there.
No, well, his shop is on the left hand side.
I've given the copies.
Madam, let me clarify it. The opening or the shutter on the eastern side has to remain open. He is to operate through the eastern side. So far as southern side is concerned, my lord, the agreement itself very clearly says that you are not to the space between the southern shutter and the road, my lord, is not to be used by
Instead of us being explained by Mr. Muzumdar all these sides, when can the contemners be in this court to explain to us in their language, which is the eastern and the we would like to understand from them.
Well, it is there in the agreement itself.
And we'd like to understand from them, we'd like to have a statement from them.
Yes.
Saying that nothing has been done after the orders of the court and all the obstructions as required by the court has been removed.
My lord, one more aspect. I think they have argued, and I'm just repeating at the cost of different things. So far as eastern side is concerned, my lord, it is absolutely open now. Absolutely open.
Was there a requirement of the orders passed by this court?
Yes.
No.
Yes.
Respondents will ensure removal of the obstruction on the eastern side.
Yes, that was removed.
And ensuring entry and exit through the southern.
My lord,
Now, whatever existed there,
my lord,
Yes.
without a modification of this order, that there is a status quo order there, I cannot comply with this order.
I'm not saying that. I'm not saying reason is, my lord. Even with the kiosk, there was a entry through the southern side also.
Ensuring entry and exit through the southern side.
Yes.
It was that we closed.
Possibly, it's possible. My lord, even if the kiosk is there, my lord, entry
The
and
question
exit
is not of a kiosk, sir.
my lord.
The question is of an entry and exit from the southern side.
Yes, that's what I'm saying.
There is no kiosk now. Kiosk already removed. For the
Yes.
said order, kiosk is gone.
Yes. Kiosk
So
is
was
gone.
the entry and exit from the southern side.
Yes, I'm saying.
Overreaching.
Page 72, my lord,
Of page 70
of the read petition.
of the.
Read petition.
I think we are overreaching. We have to take it up some other day.
Just
They have been,
one second. my lord.
they have been,
This page 70. Just one. This is totally close to it.
Page 70.
2, my lord.
2.
Yeah.
Yes.
So if you see, this is the southern side.
Which is the southern side?
It's front one.
Huh?
This
So,
is kiosk.
so now let us see today's photograph.
so they are saying this entry, this part is made.
Yeah.
This,
Kiosk
this
is
is,
now-
this
kiosk-
is, this is my
kiosk-
entry, they are saying.
kiosk is no longer-
Because they have,
We'll pass our orders.
yes, because
in
they
the
are
chamber,
trying
but I
to
think
roam
they have to
around
come
and
and
roam around, doing the things. This is,
Not-
this is the entry and then I have nothing but
My
to
lord, southern side,
submit.
they are not entitled the southern side actually under the.
That is
Have the order modified. Have
18,
the
12.
orders of the court modified, Mr. Mazumdar? Should I be advising him on that?
Eastern side, my lord, absolutely clear. He is to operate through the eastern side.
Eastern
and
side?
order says, my lord, kiosk will remain. I'm just submitting one aspect for your lordship consideration. The order passed on 1812 is very clear.
Lordship may
kiosk
pass
will
on.
remain.
These are,
Here,
he's revolving around the same thing. This is so obvious.
Pass our orders.
It cannot be more obvious than this, Lordship. It cannot be more obvious than this. I mean, what more can
My
this?
lord,
That's,
I'm
do
very,
not try to ride a running horse.
no, Lordship. Because he is 1812.
We'll have to pass our orders. They need to come and explain.
my lord.
They will have to come and explain. We are holding there is an apparent part. The southern exit, as of now, as for the photographs now placed before the court, does not convince us that the southern part has an entry or an exit. The attempt appears to be deliberate.
Southern side entry is there. Southern side, they can always enter. Lordship has seen this there.
Yes, We'll have to We have overreached.
Some other.
Yes. Twenty-fourth. List this matters again on the 24th
Further hearing.
of November 2025 for further hearing.
Lordship, the present photographs may be marked as X1.
The photographs placed today by Mr. Arjay Das shall be
Madam, can it be on 27th, man? 27th.
Yes, 27th.
Well, I was only trying to impress upon your lordship that under the agreement, eastern side he is entitled to operate, and southern side.
All Mr. Mazumdar had to do was show me that this is the order and this is the compliance. Anything which needs convincing in a contempt petition is contempt.
Deeply obliged.
If it needs convincing. Like they say that if a stay order is to be there, it is not to be argued. It has to be apparent that there should be a stay order. Yes, any urgent matter, sir?
Item number 52.
52 years.
There because.
Lordship will hear me once on 27th. I'll see in the meantime if there is.
We have passed our orders. We have said that it will be listed again on the 27th.
Man, deep down.
We'll take a call on 27th. Yes.
52, because of the petition, I am suffering. There is no interim order, nothing. Which was
Yes,
for.
we remember
Let it be on
getting
Tuesday.
something.
Let it be on Tuesday.
20?
Tuesday, next week.
Tuesday. So Mr. PK, the matter could not be taken up today due to paucity of time. Mr. PK Roy Chaudhary has expressed an urgency in view of the fact that despite there being no interim orders in the writ petition, the petitioner is suffering. The applicant is suffering. You are praying for a stay vacation.
No, my lord, nothing is no stay order, but they are not giving my.
Final disposal, my lord, it should be coming in admission, I think. Your lordship has expressed mine. And it may be, my lord, 12 or 14.
No, next
Tuesday, my lord, there is a problem, my lord. Wednesday?
List the matter again.
Wednesday, my lord.
On Thursday,
On
my lord.
Thursday.
13th of November 2025. Any other urgent matter?
Yes, your lordship, item number 54. Lordship, it may be taken up on Monday.
What is the urgency?
Lordship, there's just a short extension of time for filing of appeal, your lordship.
Filing of appeal. Some urgency has been expressed in the prayers made in the interlocutory application. This matter could not be taken up today due to paucity. This matter be listed again on Monday next, 17th, 10-11. Any other urgent matter?